right now, so just a sec.
Great, thanks.
Okay.
Great, thank you. Good morning. Today is February 24th, 21, and this is the joint committee meeting or committee on legislative committee. My tongue is not going with my head somehow, I don't know, of criminal justice and public safety. I am Senator Susan DeChambeau, and I'll begin by having our other members introduce themselves. Representative Warren.
Thank you, Senator DeChambeau. I'm Charlotte Warren, and I represent the city of Hollowell and the towns of Manchester and West Gardner in the House.
Senator Lawrence.
Thank you, Senator DeChambeau. I'm Mark Lawrence, State Senator from Southern York County, which includes the towns of Kittery, Elliott, South Berwick, Half Berwick, York, and Ogunquit.
Thank you. And Senator Searway.
Good morning. I'm Senator Scott Searway, and I represent District 16, Waterville, Winslow, Fairfield, Benton, Albion, Clinton, and Unity Township.
Thank you. And next to you in the square is Representative Lookner.
Morning, Representative Grayson Lookner here in Portland, District 37. I just gave Representative Pluker my sign-in information, so he may need to change his name, but I represent part of Portland out by the Fore River.
Okay, thank you. And Representative Rudnicki.
Good morning, Madam Chair. I'm Shelley Rudnicki. I represent House District 108, which is Fairfield, Mercer, and Smithfield. And once again, I'd like to say that we're doing a very much disservice to the state of Maine and to our constituents for these Zoom meetings. I don't think we're getting enough information across, and I just wanted to put that out there. Thank you.
Thank you. Representative Newman.
Yes, I'm Dan Newman, District 76, which is Belgrade, Rome, Mount Vernon, Fayette, Vienna, and Wayne.
Thank you. Representative Pickett.
Good morning. Thank you, Madam Chair. My name is Dick Pickett. I represent House District 116, the towns of Canton, Dixfield, Hartford, Mexico, and Peru. And Senator, Senator, also, just so you will know, I will be leaving shortly. I have to testify on Zoom in another place, but I will be back for the remainder.
Great, thank you. Representative Pluka.
Thank you to Representative Lookner for helping me get on this morning. My name is Bill Pluker. I come from Warren, represent Hope Appleton and part of Union. Thanks for being here. House District 95.
Great. And again, I'm Senator Susan DeChambeau. I represent District 32, which is the towns or the city of Biddeford, the towns of Dayton, Lyman, Alfred, Arundel, and Kennebunkport. Also with us is Jane Overton. Jane is our policy analyst who takes very good notes and then reminds us what we heard next week. And our committee clerk, Deborah Fay. Thank you. Thank you all for coming. Today, this morning, we have 3 bills before us. Is there any specific order? I see the first one, the sponsor is, wait a minute.
Senator Pouliot.
Is he with us?
Senator Pouliot is here, and he also has work over in the Education Committee. He's asked if he could go first.
Okay, fine. Thank you.
Thank you.
Before we, thank you, Asha. Senator Pouliot, we'll get to you in 1 second. Representative Sharp, would you introduce yourself, please?
Good morning, I'm Braden Sharp. I'm from District 46, which is Durham, North Yarmouth, and part of Pownell.
Thank you. And so the first bill we're going to hear is LD 369, an act to criminalize recording an incident in progress, but failing to report the incident immediately to an appropriate authority. The sponsor of the bill is with us now, Senator Pouliot. Welcome.
Good morning, Senator DeChambeau. And,
Senator Pouliot, excuse
yes.
me, this is Representative Warren. Give us 1 second, okay? Thank you. For those of you who are here but have not been invited over as panelists yet and plan to testify, please raise your hand so our clerk can see you and bring you into the room so that we know you're planning on testifying. And that will make it easier for Senator DeChambeau when she calls on folks. Once you've testified, she'll move you back so that she'll have an easier time figuring out who wants to provide testimony this morning. So thank you for that. Welcome, Senator Pouliot. We're happy to have you, and you may go ahead. Thank you.
Thank you,
Representative
Representative Warren. And I appreciate the, can you hear me?
Yes, I'm sorry, but I think I see a hand right after or during when the representative Warren was speaking. Dan Castaigne, did you have something to say or question?
Yeah, I'd like to introduce myself.
had his
I
hand
represent District.
Oh.
I represent District 100, which is part of Etna, Dixmont, Newport, Plymouth, and Corinna. Thank you.
Okay. Boy, Senator Pouliot, you've got patience. Go right ahead.
Hey, no problem at all. Thank you very much, Senator DeChambeau and Representative Warren. And thank you for the indulgence of the committee moving this up. I've got a work session over in EDU, so I'll have to hop over to that after. But I appreciate the opportunity to join you today, although I really wish it were in person, to present an act to criminalize the recording of an incident in progress, but failing to report the incident immediately to the appropriate authority. That is one tongue twister of a title, but I think fairly straightforward, gets across what we're trying to do here. This particular proposal was something that was brought to me by a constituent. And he was very concerned that individuals are recording incidents that are taking place, such as shootings, accidents, and the like, and not calling 911, but instead recording the crime. I hadn't really contemplated this, frankly, before, but after he brought it to my attention, it seemed like a reasonable thing for us to at least have a discussion about. This bill makes recording by electronic device an incident in progress, such as a crime or an incident involving serious bodily injury or death, but failing to immediately report that incident to an appropriate law enforcement or emergency response authority, which may include calling 911, a Class E crime. The first thing that anyone should be doing if there is an accident or a crime taking place is call 911. We all are taught that from a very young age. It's something that's afforded to us to do, and we should make ourselves, make that a priority. And then also making sure, that people are safe, not recording things for social media or personal use. So for someone who does not report this, I think there needs to be some consequences. And, I recognize fully that this is probably going to be something that would be difficult to enforce. And that's not lost on me. But I think that by having this discussion and hopefully by putting this in place, the public will be aware that their first step really ought to be to report an incident, not make a recording of it to share on TikTok or Snapchat or Facebook or whatever. That really it's important that we're contacting the proper authorities so that these issues can be addressed. So I thank you for your time, and I'd be happy to answer any questions that you may have.
Thank you. And I forgot to mention, we do use a 3-minute clock, so we'll be doing that for every speaker. Anyone have any questions for Senator Pulliam? Seeing none, thank you.
Thank you.
And I will ask if there are any legislators who wish to speak on this bill. Seeing none. Anyone in support of this bill who would like to testify? I don't know if everybody's here. Okay. I don't see anyone wishing to testify in support. If something comes up, I'll go back. I don't know if this is a technical problem. Anyone wishing to speak in opposition of 369? I see 2 participants now. Now it's picking up. I believe the first one was John Pelletier of Clack. John, are you with us?
Yes, I'm
Oh,
sorry.
there's a
Thank you
problem
very
here.
much, Senator DeChambeau.
Okay, hi there. Good.
Senator DeChambeau, Representative Warren, members of the Committee on Criminal Justice and Public Safety. My name is John Pelletier. I'm the chair of the Criminal Law Advisory Commission, and the Criminal Law Advisory Commission is not in favor of this proposal. And, first of all, there's the fundamental question about whether individuals have a duty to report a crime. And in Maine, they do not. And there have been various proposals over the years about requiring people to report crimes in certain instances, and the legislature has rejected those. But on the base question, should there be an obligation of citizens to report crimes that they observe, the commission, when we discussed it, we did not see whether making a recording as sort of a relevant criteria. If you make a recording, you have an obligation to report it, but if you don't record, you don't have any obligation to report. So we didn't see that as a relevant criteria. It does. I mean, the concept that the constituent brought to Representative Pouliot is out there. Why didn't people intervene? That sort of thing. But on the other hand, in our discussion, there's been beneficial effects from videos being broadcast, and sometimes information that's very much in the public interest comes to light. And a law like this would discourage the recording and those public recordings that are in the public interest coming to light. It would discourage that. Finally, we're just our group. It's been a consistent position that Maine has taken a long-standing position to rarely impose duties to report on its citizens, and the Clack Commission is in favor of that. We have in the criminal code, you have to report, a physician has to report treating a gunshot wound, and corrections officers need to report if they see another corrections officer committing sexual abuse on an inmate. But other than that, we don't have strict reporting requirements, and most of the reporting requirements that exist in other statutes are not accompanied by criminal penalties, but by civil penalties. So that's our position, and I'll stop and be glad to answer any questions.
Yes. I see a hand. Senator Stairway, you wish to ask a question of Mr. Pelletier?
Yes, thank you, Senator DeChambeau. I just wanted to know, John, is it possible to I hear what you're saying, and I just was wondering if it's possible to amend this to put an exploitation of a recording in a serious bodily or death or something like that to be a crime.
I'm not sure what you mean. Are you suggesting that if the perpetrators recorded it and somehow put it out there to in an attempt to glorify the conduct, that should give rise to an additional criminal penalty?
Yes.
It seems to me that I'll just say two things. First of all, it strikes me as a drafting challenge. And second of all, as you know, our criminal code provides broad ranges of sentencing authority to a judge. And it seems to me that if someone, particularly if they're engaged in brutality, something that you and I might be thinking about right now, serious conduct, and they record it and they put it out there in an attempt to glorify what they've done, it seems to me that that would be brought to the attention of a judge and would be a serious factor considered by the judge, leaning in the direction of a much harsher sentence. I think there's a way to deal with it now, and I'm not sure about drafting something that could technically narrowly get at what you're getting at.
Yeah, I'm just thinking, if somebody videotapes somebody being, we'll just say being sexually abused, that's exploitation if they put that forward somewhere, or maybe somebody being beaten up or something like that. To me, how do you get it in front of the judge if you don't have the crime?
Well, because
I'm going to stop you. I'm going to
don't apply. And
excuse me, Mr. Pelletier. I'm going to stop you there. I'm going to remind the committee members that today is a public hearing. Today is a time for asking clarifying questions of folks who are delivering testimony. This conversation that we're having right now is completely appropriate for a work session, but today is about clarifying questions. So thank you, Mr. Pelletier.
Thank you.
Any other members of the committee who have a question of Mr. Pelletier and his testimony? Seeing none, thank you, Mr. Pelletier.
Thank you very much.
And now, okay, I believe Michael, yeah, I'm gonna get it right by the end of the term, right?
Senator, just call me Michael. Just call me Michael. It's okay.
Okay. Michael K. All right.
That's great.
Sounds like a basketball player. Go ahead.
My favorite novelist is
yes, and follow
Michael K.
And I will tell you, Michael, Tina Nato will follow you, okay? So go right ahead.
Senator DeChambeau, Representative Warren, and distinguished members of the committee, good morning. My name is Michael Cabeda. You all are all free to call me Michael, and I'm policy counsel for the American Civil Liberties Union of Maine. I urge you to reject LD 369 because it would violate the federal constitution, shield police from public scrutiny, chill free speech, and unduly expand our criminal code. If enacted, this bill would make it a crime for a person in Maine to fail to report a crime if the person also records the crime. Such a requirement would endanger our First Amendment right to record police doing their jobs. 10 years ago, the First Circuit, the highest federal court in New England, recognized this right in the Glick case. The facts of that case are instructive here. In 2010, Mr. Glick sued 3 police officers in the city of Boston for violating his civil rights after police arrested him and charged him with illegal wiretapping, aiding the escape of a prisoner and disturbing the peace. All this for holding up his cell phone and openly recording Boston police officers as they punched another man on the Boston Common in October of 2007. As a defense, the officers argued that there was no First Amendment right to record police, or if there was, the law was not clear and they should be immune from being sued. The court decisively rejected both of those claims. If the principles in LD 369 were in force in Boston in 2010, then Mr. Glick would have been charged with yet another crime. Failing to report a crime to the very institution that violated his civil rights, the Boston Police Department. The obligation would put Mr. Glick in an absurd position. It's inherently bad policy to prevent Mainers or anybody in the United States from recording police doing their jobs. Indeed, as members of this committee will vividly recall, the event that sparked outrage and protest around the country last year was a cell phone recording of Minneapolis police officer Derek Chauvin killing George Floyd. Imagine if the person recording that event also had to immediately report it to the police and faced a criminal charge if they failed to do that. As we saw in the video, 3 police stood and watched as life left George Floyd's body. The rule in this bill would have put the bystanders who recorded George Floyd's killing in an impossible position. The First Amendment protects citizens' right to film police. Videotaping also protects the public's right to know when police who are funded by tax dollars break the law. This bill would violate both those rights. It would do so by expanding our already vast criminal code. We urge you to vote ought not to pass. And I thank you for your attention.
Good. Thank you, Michael. Anyone have any questions? Seeing none, again, thank you. And Tina, you wish to speak in opposition? Yes. Okay. Tina Nato, please.
Good morning, and thank you, Senator DeChambeau and Representative Warren and all the familiar faces I'm seeing, and quite a few new ones. I am not Walt McKee. I am Tina Nato. I am the Executive Director of the Maine Association of Criminal Defense Lawyers. I am presenting testimony that Walt has prepared on behalf of our Legislative Committee in opposition to LD 369. It's difficult to understand, even in listening to the Senator's presentation initially, to understand where this bill is coming from. As it stands now, every person in the United States is freely allowed to record an incident in progress that might involve criminal activity, and they are under no obligation to do anything with that recording, other than in very limited circumstances. For example, the healthcare worker having to report a gunshot wound. There has never been a requirement in Maine that affirmatively requires that a person report criminal activity, which is just what this bill is trying to do. There is no general Good Samaritan requirement in Maine, and for good reason. Forcing individuals to take certain actions that they are otherwise not required to do is a violation of the Maine Constitution as well as the United States Constitution. This is a very classic, quote unquote, big brother bill. Countries of old who were ruled by dictators who encouraged reporting on one's neighbors had laws just like this, and it created a system of fear that tore through the core of these societies. Indeed, failing to provide information to the state as required in this bill would result in a conviction of a Class E misdemeanor crime, which carries with it a sentence of up to 180 days in jail. The few laws on the books that require people to affirmatively report a crime involve narrow situations where the person is actually involved in the event, such as those who are involved in accidents who have to report them by quickest means, or to remain at the scene of the accident and provide information to another person involved. Of course, we also have mandatory reporters in this state regarding child abuse. But this bill is a far cry from that. They require that unless a person immediately reports anything that they recorded that possibly could be a crime, they themselves could be prosecuted and imprisoned for up to 6 months. We agree with Clack and Mr. Pelletier's conclusion that people will actually be discouraged from recording if this bill were to be passed, and we just feel that it runs afoul of the First Amendment, the Fifth Amendment right to not incriminate oneself, and so many other amendments. So we are just completely opposed to this bill, and I'd be happy to answer questions.
Senator, you're on mute.
Thank you. Anyone have any questions of Ms. Nato? If not, I didn't see anybody. Oh, Senator Seaway.
Thank you, Madam Chair. I just wanted to clarify, I thought this bill was for serious bodily injury and or death, not any videotaping?
It says in the bill itself, an act in progress that the person knows or has reason to believe is criminal activity or an incident involving serious bodily injury or death. So not only does the person have to know the criminal code to see that this could possibly be any crime, it could also be something with bodily injury, but that's not a requirement.
All right. Anyone else have any questions? If not, thank you very much.
Thank you very much.
Anyone else wish to speak in opposition of this bill? Seeing no hands raised. Okay. Anyone wish to speak neither for nor against LD 369? Seeing none, I will close this and we shall continue. I am going to ask Representative Warren, could you take over? I had a problem with my printer and I need to do something before I can continue.
Sure, happy to.
Representative Warren, can you?
Sure, happy
She's
to.
frozen. Oh, great, thank you. I'll be right back. Yeah. Go ahead.
Great. Okay. Thank you, Senator Pouliot. Let me just get to the schedule here. Up next, we have a public hearing. I know Representative Morales is in another committee on a bill. I'm not sure if she's back with us. So Representative Costain, are you prepared for your bill, LD 419?
Yes, ma'am.
Wonderful. So this is LD 419, an act regarding participation in public works projects by pre-trial inmates. And for folks that are in the waiting room, would you raise your hand if you plan to deliver testimony, and Deb will move you over. And thank you, Representative Costain.
Good morning. Senator DeChambeau, Representative Warren, and members of the Joint Standing Committee on Criminal Justice and Public Safety. I'm Dan Costain. I represent House District 100, which includes the town of Corinna, Dixmont, part of Etna, Newport, and Plymouth. I'm here today in support of LD 419, an act regarding the participation in public works project by pretrial inmates. To me, this bill is important for a couple reasons. First, it gives an inmate the opportunity to shorten the sentence by participating in a work release program. Secondly, by staying positive, we have seen how it can increase morale while helping to improve public works related projects, as well as helping charitable organizations to do the same. This program will be overseen by the sheriffs of a county jail or the sheriff of a county that shares a regional jail with their counties. We have seen many positive aspects of different work release programs, and I believe this bill fits into the spirit of what they are intended to do by providing an opportunity to an inmate to be productive and potentially shorten their sentence, as well as improving the community as well. Please join me in supporting this bill, and I welcome any questions.
Thank you, Representative. Any questions for Representative Costain? Seeing none, yes, Representative Lookner.
Thank you, Madam Chair. Thanks, Representative Costain. I'm just curious, does pre-trial mean pre-conviction?
Yes.
Okay, that's all.
Any other questions? Seeing none, I'll now take testimony for those in favor of the bill. And if you would like to provide testimony, please raise your hand. And you can either do that with the function or just literally raise your hand. Hi, Sheriff. Good morning. Sheriff Morton, welcome.
Good morning, Representative. I couldn't find the little hand down below, so I went with the one up front.
Perfect.
Thank you so much for having me today. Senator DeChambeau, Representative Warren, and honorable members of the Joint Standing Committee on Criminal Justice. My name is Troy Morton. I'm the Sheriff of Penobscot County and also the President of the Maine Sheriff's Association. Maine Sheriffs met to discuss this bill, and our position on LD 419 is to support with a modification. I'll explain that at the end. The bill came to fruition through discussions with membership of the Maine Sheriff's Association. One of the ongoing struggles for Maine's county jails is overcrowding. While the onset of COVID-19 alleviated overcrowding to mitigate spread of the virus, some jails are again facing shortage of beds. While available beds may be one facet of this bill, there are other benefits that could better the lives of those who find themselves within our jails. Upon arrest and incarcerations, inmates find themselves behind bars waiting for their case to make its way through the judicial process. Due to the current court virus restrictions, Maine's courts are facing backlogs that seem insurmountable. Our pretrial inmates are waiting longer than ever for their cases to be heard. Providing opportunities for inmates to participate in public works programming benefits all parties. Not only does this allow the county, the municipalities, and nonprofits to access affordable labor, it also exposes inmates to productive skill sets that could provide them with work opportunities once they are released. Self-esteem has long been a discussion item when measuring tools to reduce recidivism. We see potential value to provide the ultimate result by providing these productive jobs to our pretrial population. The modifications to this bill that I referenced earlier pertains to the admission and the language in front of this committee. The admission content would allow pretrial inmates to earn time to be applied towards their ultimate sentence if they are indeed sentenced. For years, Maine sheriffs have collaborated with many members of this committee to find and or expand what we offer inmates to provide to improve their stay in our jails. We believe the outcomes of using pretrial inmates for public works projects is an effort that we can all get behind, and we urge you to support LD 419. I thank you for your consideration, and I'm happy to take any questions that you might have.
Thank you, Sheriff. Any questions for Sheriff Morton? Seeing none. Thank you. Anyone else here to testify in support? Oh, excuse me, Senator Searway.
Thank you, Madam Chair. Sheriff, I worked in the jails and I understand, we have the bail system, we have conditions of release, and I'm just kind of wondering if they're not sentenced, are we actually kind of like setting them up to be sentenced because they are not found guilty or not guilty? At that point, there's evidence that they may be guilty, but seems like we're putting them to work before sentencing, and I don't know if they become volunteers if they found not guilty. How's this work?
So thank you, Senator. All great questions, and I'm glad you actually give me a chance to expand on this a little bit. This is absolutely volunteer. And this concept actually came from defense counsel that regularly meet with me. We have a great relationship with our court system here, including defense and prosecutors. And listening to defense counsel that are talking about their clients who are potentially going to be sentenced. They may be in the process of working out plea agreements, and they know that these individuals may be sentenced, but sometimes that process, even waiting, could take months. And so they're setting months waiting for the same opportunity that they could have today. And we have to be mindful that sitting in a cell block, staring at cinder block walls is not productive time for anybody. Having them have the ability to participate in programming in the jail, which could include working in the kitchen, working in the laundry, providing custodial services, sometimes services outside a facility. As you know, I testified in front of this committee before, we have a 911 sign making project here that inmates participate in. They learn the computer skills to print the 911 tags that go on signs. These are all productive means. And those that, again, you know, that are low risk, no risk, that we continue to pull out into our main pretrial services are very helpful. So again, this comes from prosecutors, it comes from defense counsel that are looking for those who want to volunteer, those who may know that they're going to be sentenced at some point, are waiting for that time, could actually earn time off their sentence now and honestly learn some productive skill sets that help them. I'm happy to share many or one excellent example of that. If you care to hear of a story that we had take place here with involved an individual who worked in the kitchen and went on to work in a big restaurant chain in our area.
Just to follow up, just asking if it could be just for inside the jail instead of outside if they're not sentenced.
That's certainly something that could be established. So as you probably know, Senator, those restrictions that allow somebody to have access to freely walk into the laundry or a kitchen where there's utensils and things like that are based on security and classifications and charges and things like that. The same with releasing individuals to work outside the facility if they're not supervised or supervised. Goes along with the classification process to make sure. But certainly if that's something that the committee would like to see through work session or whatnot, I'm not opposed to it. I just think that this gives a great deal of opportunity. We have to remember, Senator, more than 70% or around 70% for most county jails are pretrial individuals. And when people are setting for long periods of time, this committee itself has asked us, try to come up with better solutions, better programming. I can't think of a better solution for those that want to participate. We have inmates in our sewing program that simply want to sew ripped jail uniforms. What a great training skill. They also made, as you recall, we testified last year to the beds that were made for blankets that were made for veterans down in Togus. And then also they made a bunch of beds for pets at the adoption centers. So these are programs that go on, and those are just a few in my jail, and there's many throughout the county jails throughout the state.
Thank you.
Senator DeChambeau.
Hi, thank you. If you answered this, I came in late, I'm sorry for that. It says may permit. You have sentenced prisoners and they are available to go work in the community, are they not?
Yes, certainly some are, if they're eligible by classification and whatnot, they are.
Okay.
And then also inside the facility. Most of them, Senator, as you may know, the times have drastically changed with our populations as we continue to make sure that low risk, no risk individuals move through the system much quicker than they did decades ago. The amount of sentenced inmates in our jail have really come down and the pretrial numbers have gone up. And so those sitting in county jails that have longer sentences may or may not be eligible for these type of programs.
So these non-sentenced people or awaiting trial would go through a similar classification, therefore, right?
Right. They would anyhow, regardless of whether they're in a program or not. They're all classified through the intake and admissions process.
And one more, because it's a concern of mine, and thank you for stating that there are less and less sentenced and more pre-trial. Now, you engage in the very good pre-trial services. What concerns me is, other than not being able to pay bail or get out on bail, is this something that the main pretrial services would be involved in? I'm also thinking of, if they're not out of the jail because main pretrial probably did not see them as an appropriate candidate to be out in the community, would this bill supersede that? And could the sheriff let them out?
So as you may or may not know, we have a great deal of influence with our main pretrial services, but we trust the resources that they use, the procedures that they go through to classify whether somebody is eligible for main pretrial services. If somebody's not eligible for main pretrial services, this would not eliminate them for doing this process. And again, to be quite frank, I'm throwing a percentage out there, and this is just kind of throwing it out. I would say 75% of these functions, these positions, are inside the facility. Kitchen assistant. We have 6 or 8 people working in our kitchen, helping in the kitchen, 2 or 3 doing laundry, and many more doing custodial type work. So, and again, most importantly, Senator, this is volunteer. This isn't somebody's going to be directed to work. This is something that they may want to participate in order to gain some of those skills. Perhaps, again, with their legal counsel directing them that they may be sentenced, this is a great way for them to start earning time now, because they'll only earn time served. But in working, as you see in section 2, which I think is accidentally omitted from your portions, it explains how many hours they work, and it removes time from their sentence. That's how it actually is cited in that title.
Thank you, Sheriff. Representative Costain.
Thank you,
And
Madam Chair.
Representative, I'm just going to remind you that we do have a shared rule that if you've presented the bill, you don't ask questions. But if you have a clarifying question, let me see if my co-chair agrees. Oops, I don't see her. So we will give you permission to ask the question, but I just want to remind you that we did agree we wouldn't normally do this, but go ahead.
No, I will withdraw my hand if that's the case. I just wanted to clarify something, but that's fine.
Go ahead and clarify.
I just wanted to clarify with the sheriff that this bill would change it so pretrial people could do this. At this point, pretrial people can't. Is that correct?
That's correct. And that's really, yeah, absolutely, Representative. That's the challenge for those that are sitting here pretrial that are again, potentially knowing that they're waiting for a plea agreement deal that may be a month or 2 out, even 6 weeks out. They could start immediately in this program if they qualify and start earning additional time off the sentence if they are in fact convicted and sentenced. Again, this goes back to the tremendous amount of work we've done with Representative Waring on trying to come up with solutions that better the opportunities for those that are incarcerated. And I can't think of one that we should get behind more than this simple amendment to a bill it's already there for sentenced individuals. Thank you.
Thank you. Representative Costain, thank you. That's a really important clarification. Other questions for Sheriff Morton? Seeing none. Thank you, Sheriff.
Thank you,
Others here to testify in support of LD 419?
Madam,
Yes, Senator. I think we've lost Senator DeChambeau. Anyone here to testify?
Yes.
In
I've never had a problem with this, and today I did, and I apologize, Sheriff Morton. Oh my.
Anyone here to testify in opposition to, and did I get everybody that wants to testify in support of LD 419? Looks like I did. Anyone here to testify in opposition to LD 419? Thank you. Anyone here to testify neither for nor against LD 419? Yes, Michael.
Thank you, Senator DeChambeau, Representative Warren, distinguished members of the committee. Good morning again. I'm Michael Cabetta, Policy Counsel at the ACLU of Maine. On behalf of our members, I'm here to testify neither for nor against this bill. Improving the quality of life for people in jail awaiting trial is one way to reduce the barbaric impacts of our prison system and jail system. This bill would give those people in jail who are there pretrial a chance to take part in public work related projects in the improvement of property owned by charitable organizations in Maine. Unlike a person serving a sentence in jail, a person in jail pretrial is still legally innocent, as Representative Costain just clarified. For that reason, participation in such a project must be completely voluntary and not coerced nor mandated in order for it to be legal. We are testifying neither for nor against because it's unclear from the way the bill and the law are written whether pretrial inmates' participation in public works projects would be completely voluntary. Sheriff Morton's testimony suggesting that all participation is voluntary is heartening, but we haven't found strong enough grounding in the law to confidently support this bill. Thank you for your attention, and I'm happy to try and answer questions.
Thank you, Mr. Cabetta. Questions? I just have a question for Jane. And I'll wait to the work session. I want to make sure that this is voluntary. I know that Representative Costain and I had a conversation about this. I signed on as a co-sponsor, once I made sure that this was voluntary. So maybe Representative Costain could work with our analyst just to make sure before the work session that legally this says what the representative intends and what the sheriffs intend. Jane, does that make sense? Thank you very much. Representative Pickett.
Yes, I just want a point of clarification. The last speaker we just had, I think I heard them say they could not support the bill, but they testified as neither for nor against. So I'm just kind of want clarification on that if they want to be in the record, because the last statement I think was I cannot support the bill as it's written or something of that nature. Just
Are you
some clarification
of Mr. Cabetta?
Yeah, I'm just asking for clarification.
Okay.
If he is neutral on it, he's neither one way or the other, or if he is actually in opposition to it.
Oh, we are not in opposition to it, Representative Pickett. We are testifying neither for nor against. We support the spirit and the intent of the bill. We just aren't sure that the legal language prevents participation in public works projects in 100% of the cases to be completely voluntary. And so that's the concern that we wanted to raise. But we do support the spirit and the intent of the bill, but we're testifying neither for nor against. I hope that clarifies your question, yeah.
Thank you. Any other questions for Mr. Cabetta? Seeing none. Thank you. Anyone else here to testify neither for nor against LD 419? Seeing none, I'll close the public hearing on LD 419. Thank you all. Thank you, Representative Costain. That brings us next to LD 417 by our very own Representative Morales. For folks who are here as attendees, if you could please raise your hand if you'd like to testify. Deb will bring you over into the meeting as Representative Morales gets started. Thank you, Representative.
Thank you very much, Madam Chair. Senator DeChambeau, my esteemed committee members, it's a pleasure to be here before you today. I'm Victoria Morales. I represent House District 33 in South Portland, and I'm sorry I'm not here with you in the morning. I was testifying on another bill, so I'm really happy to be here now. So the bill I'm presenting to you today, it's LD 417. It's an act to protect Maine drivers from pretextual stops, traffic stops. And the intent of this bill really is to create a law enforcement policy that prioritizes public safety and ends the focus on minor traffic violations. that disproportionately impact poor people in Maine and Black, Brown, and Indigenous people in Maine. And before I begin to talk more about it, I want you all to know that I am always willing to work with all stakeholders to find a way that we can achieve this goal, to arrive at a policy that makes the most sense and that really gets at public safety and doesn't harm folks. The truth of the matter is that there are so many traffic violations, and that if a law enforcement officer were to follow any one of us for 15 minutes, they would have the discretion to pull us over for a number of minor traffic violations, whether that be following another car too closely, going 4 miles per hour over the speed limit, going too slow, not fully stopping at a stop sign, turning too wide, driving in the left-hand lane, turning too narrow, touching a white or center line. You all know all the things, but there's a lot of them, right? And we don't often get pulled over for every single one of those. A pretext traffic stop is exactly what it says. An officer stops a vehicle for one reason, and it's usually a very minor reason, although it's unlawful because it's a law in the books. But they don't stop that vehicle because they want to enforce that law and write a ticket for that reason. No, that reason serves as only a pretext, a tool that the officer uses to stop the vehicle and then explore whether further crimes are being committed based on hunches and intuitions, as opposed to the legal standard of reasonable articulable suspicion. The problem with this is that both hunches and intuitions are based on implicit bias, which we know to be the attitudes or stereotypes that affect our understanding and decisions in an unconscious manner. And because pretext stops are discretionary, bias often becomes the driver of the officer's decision and ultimately results in stopping more people of color and more poor people. Pretext stops in this country became legal in 1996 when Justice Scalia wrote the Wren opinion in the US Supreme Court. Now we've come a long way in 30 years in terms of how this policy has impacted our communities. And I submit to you that this practice of using pretext stops as a reason to stop Maine drivers really damages the public trust and is harmful to those disproportionately impacted. According to the US Department of Justice in 2015, 8.6% of the driving population was pulled over, and Black or males earning less than $24,999 a year were more likely to be pulled over. According to the Stanford University Open Policing Project, an interdisciplinary team of researchers that have gathered over 200 million police records across the country to analyze vehicle and pedestrian stops, Black drivers were 20% more likely to be stopped than white drivers. Further, once stopped, Black drivers were searched about 1.5 to 2 times as often as white drivers, even though they were less likely to be carrying drugs, guns, and other illegal contraband compared to their white peers. We often hear, and I'm sure that you will hear today, that pretext stops are an effective tool to battle the war on drugs. However, an Illinois study in 2016 showed that out of 2.17 million traffic stops in that year, just 8,938, or 1 in every 242 stops, resulted in contraband being found. Given how little is gained from these stops, it is difficult to justify the harassment, the embarrassment, or the inconvenience, particularly when those most impacted are people of color and poor people. Although Maine doesn't collect data on pretext stops yet, because I believe that we will, there is no reason to think we're exceptional, given what we know about our prison population in Maine, with 12% of our adult prison population being represented by Black people and 23% of our juvenile prison population being represented by Black juveniles. A deep review of pretext policy falls squarely within our legislative purview. And I believe we can and we should set the policy right in Maine to make sure and to help law enforcement so that we prioritize public safety by requiring that they have reasonable articulable suspicion of a true public safety violation that they are ready to act on when they pull over a vehicle. So I thank you very much for the opportunity to present this to you, and I welcome a robust discussion about this.
Thank you, Representative. Any questions for Representative Morales? Seeing none.
Yeah.
I'm gonna. Oh, Representative Pickett, you're not muted. Seeing none, any legislators here to testify? Seeing none. Oh, excuse me, Representative Johansson. Hi, we miss you in this committee. How you doing?
Good, thank you. And I miss everybody on criminal justice. I am not speaking in favor, so if that's okay for me to start, I'll go ahead.
Well, the normal rule is that all legislators go first. And so if you'd like to wait till the opposition time, you're welcome to. But if you've got other things to get to, you're welcome to deliver your testimony now.
I'm in another committee also, so thank you very much.
I figured. You're very welcome. Go ahead.
Good afternoon. My name is Chris Johansson. I represent House District 145, the 18 organized towns in southern Aroostook. LD 417, this bill is a pretext to fix a perception that Black and brown people are stopped, arrested, and imprisoned at a higher rate than whites. Proportionally, they are. But why are we sidestepping another injustice in the numbers? According to the 2019 Uniform Crime Report, 4.3 million males were arrested and only 1.6 million females were arrested in the same year. Can anybody tell me why there's such a disparity in the number? You're thinking it, so go ahead and say it, because cops go where the crime is. Men commit more crimes. And I'd like to bring up a scenario that I can see with this law. A motorist stopped for speeding. While we're talking to the operator about his speeding, we suspect he's drunk. And there's a lot of indications that he's drunk. What do I do with this fellow? While I'm trying to decide that, dispatch says there's a warrant for his arrest, which is a command by a judge to take this person and bring him to the sheriff, and command to the sheriff to bring him into court. Do I just let him drive on drunk and warrant? So I would just like you to all to consider these points I brought up. And thank you very much for listening to me today.
Thank you, Representative Johansson. Any questions? Seeing none. Now I'll take testimony from people here to testify in support of LD 417. So if you're here to testify in support, please raise your hand. And I'll start with Michael Cabetta.
Thank you, Representative Warren, Senator DeChambeau, distinguished members of the committee. I'm Michael Cabetta, Policy Counsel for the American Civil Liberties Union of Maine. And on behalf of our members, I urge you to testify to support LD 417. The best national data, as summarized by Representative Morales, that we have on pretextual traffic stops tells a consistent story. Black, brown, and indigenous people are more likely than anyone else to be stopped and more likely than anyone else to be searched. Representative Morales summarized the data, so I won't duplicate her testimony. She also described data showing that people of color are not more likely to engage in criminal activity, contrary to what you just heard from Representative Johansson, and in some cases are less likely to engage in certain forms of criminal activity than white people. But I will describe how Maine conforms with this national picture. On August 15th of 2019, Maine State Trooper John Darcy pulled over a Black man who was driving north through York on Interstate 95. The internal microphone in the cruiser recorded the officer's comments to another trooper moments before the traffic stop. Officer Darcy said, quote, "This guy kind of looks like a thug, to be honest with you," end quote, according to a transcript in one motion in that case. Darcy also said that the driver, an African-American man, looked, quote, like a thug because he's, quote, wearing a wife beater and, quote, he's got dreads, which refers to dreadlocks, a hairstyle that African Americans and people from the Caribbean use and wear. This specific case is a small window into a larger picture of dramatic disparities in who is pulled over in Maine. According to a national ACLU study released last year, Black people in Maine were 4 times more likely than white people to be arrested for cannabis possession. In York County, Black people are more than 12 times more likely than white people to be arrested for cannabis possession. These disparate rates, as you just heard from Representative Morales, do not reflect a disparate rate of possession of cannabis. Instead, these rates reflect a racially disparate rate of police interactions with the public. In many cases not captured in these data, pretextual stops result in no charge. But the impact of a pretextual traffic stop cannot be overstated. They erode respect for the law and traumatize drivers, especially drivers of color. This bill would help Maine take a small step away from the harms associated with pretextual stops. We urge the committee to support it. I thank you for your attention and welcome questions.
Thank you, Mr. Cabetta. Questions? Mr. Cabetta, is that the police officer that received the Trooper of the Year award from the Maine State Police? Is that the same one?
I'm not sure, but I see that Suzanne is nodding. So perhaps you can ask her when she testifies.
Thank you. Any questions for Mr. Cabetta? Seeing none. Thank you, Mr. Cabetta. And next up, we have testimony from Mr.
I have a question. I'm
Oh,
sorry
yes.
I didn't raise my hand.
Senator, go right ahead.
And yeah, and thank you, our clerk, for telling me to close my computer and start all over. So I guess I get a better connection. I'm just curious for you to explain a little further. My ears perked up when you said York County, which is my county. When you said 12%, is that higher than the rest of the state per county? 12%, I believe. Would you qualify that, what that meant?
Yes, Senator DeChambeau. What I said was actually very shocking data. I was very surprised to read it myself. I spend lots of time in York County and very much enjoy what the county has and offers. The data is that Black people in York County were 12 times more likely to be arrested for cannabis possession.
Okay.
12 times more likely than white people. And that was the highest number in Maine. And the statewide statistic is 4 times more likely. Black people are 4 times more likely to be arrested for cannabis possession.
Yeah. Well, I don't know if you can answer this other question, but of that 12%, were those in communities? And you don't have to answer it, but my experience has been mostly on Maine Turnpike.
Yeah, that's it. Yeah, I dug into some of the data, and you're right. Most of the data comes from traffic stops, and that's why that data is so relevant to this bill, because this bill targets mostly pretext traffic stops, and so not in communities but on the roads.
Thank you.
Absolutely.
Any other questions? Seeing none. Next up, we have Mr. Pratt. Welcome.
Good morning. Thank you, Representative Warren, Senator DeChambeau, and members of the Criminal Justice and Public Safety Committee. My name is Jeremy Pratt. I'm the Vice President of MACDL, the Maine Association of Criminal Defense Lawyers. I reside and practice law in Camden, and MACDL supports LD 417. Pretext stops are when law enforcement use a minor traffic offense as an excuse to pull over a driver in order to investigate something else. This something else is not sufficient for law enforcement to pull the person over independent of the minor traffic infraction. In order for law enforcement to pull over a vehicle, law enforcement only needs to have reasonable, articulable suspicion that a crime or civil infraction has occurred or is about to occur. That is an extraordinarily low standard. If law enforcement cannot meet that low standard, it means they have no evidence of wrongdoing, but instead are relying upon a hunch. as Representative Morales said, motor vehicles and operation of motor vehicles are extraordinarily regulated. And there are many rules governing their operation that are open to interpretation. And essentially any person could be pulled over at any time just by being followed by law enforcement for a very short period of time. The one objection that I've heard repeatedly, I'm trying not to repeat the testimony of the two individuals who spoke before me. So the objection appears to be largely to this bill from Senator Johansson and from some of the written testimony that was submitted, is that law enforcement won't be able to do their job if this bill passes. This bill does no such thing. If during the course of a legitimate non-pretextual stop, law enforcement develops reasonable articulable suspicion, again, that's an extraordinarily low standard, that another crime has occurred, that in that point, law enforcement may investigate the new crime. Take, for example, the following scenario. Law enforcement pulls over a vehicle for an out tail light. And the reason for pulling over is the out tail light and for no other reason. Law enforcement then interacts with the driver and develops reasonable articulable suspicion that the driver is impaired. It is at that point that law enforcement can investigate and question the driver about being impaired. Again, nothing in this bill prohibits this. To put it in the simplest terms, what this bill makes law is that you need a reasonable articulable suspicion to do something, and you cannot take reasonable articulable suspicion and transfer it from one thing to another. I see my time is about up. I'm happy to answer any questions about this concern that is raised about law enforcement's ability to do their job or any other issue regarding this bill. Thank you. And again, MACDL strongly supports its passage.
Thank you, Mr. Pratt, for your testimony. We're going to take questions, and I see Senator Searway.
Thank you, Mr. Pratt. And thank you, Madam Chair. And Mr. Pratt, just where would the line be drawn, what you're explaining? I guess, because if it's an unsafe situation and you're trying to figure that out as law enforcement officer. I mean, right now we're one of the safest states in the country, and this to me is going to make it unsafe for an officer, and that's what I think the officers are feeling, and with this bill. And I just want to know how that line's drawn.
Again, it won't prohibit law enforcement for pulling anyone over as long as they have a suspicion that they can reasonably articulate. That's all it does. So any officer who sees a crime that has occurred or is about to occur, and they want to investigate that actual crime, and they can articulate the reason why, then it's completely allowed. I'm not sure how that limits the safety of law enforcement. And then if they pull someone over and they see that there is some other issue that has arisen after that person is pulled over, they then can investigate the new crime. I don't think it limits it anything at all. It just makes sure that the reasons that people are being pulled over are legitimate and for the reason that law enforcement claims it's to be, and not for any other reason. I hope that I attempted to answer your question. You were jumping around on my screen, so I was trying to follow you because I can't help but try to still follow the picture of someone. But I hope that answers your question.
Other questions? Representative Pickett.
Thank you, Madam Chair. Thank you, sir, for being here. Just have one question. I'm aware of what the bill does, aware of what a pretextual stop is, of all of that stuff. But that being said, how do we set back as Monday morning quarterbacks? How do we set back and determine what an officer is thinking in conducting a traffic stop? There's a lot goes on to conducting a routine traffic stop. A lot going on. And the thing that bothers me is the fact that we're targeting one set or a set of individuals that we think are being harmed by being stopped. And maybe they are, maybe they aren't. I'm not getting into that at the moment. But I think we're just saying that police officers don't have anything better to do than to go out and in their tour of duty, go out and find reasons to stop people for crimes they suspect them of doing. I'm not saying, I'm just saying that's kind of what I'm hearing here a little bit. And I just want some clarification on that from those that oppose this. I mean that are supportive of it. How do we do that? How do we determine what an officer is thinking in conducting a traffic stop to be able to make these statements about what they're doing and how they're doing it?
Thank you for the question. And I think it's a great question because it's difficult to determine what the intent of the officer was when they pulled someone over. So frankly, unless if they make some sort of statements like they did on the case that was earlier described on recording, it's going to be hard to make that determination. But the reality is, in my practice, many law enforcement officers will get on the stand and admit that they didn't care about the out tail light, that they didn't care about the minor traffic infraction, and they only wanted to investigate something else. So frankly, a lot of it is only going to be enforceable if law enforcement makes that admission that they are pulling over people for an excuse. However, I think that there are other objective ways we could look at it as well to figure out what their rationale. If law enforcement never pulls over someone for a certain type of infraction and they've been a law enforcement officer for 20 or 30 years, I think that would raise an eyebrow, and we would present that information to a judge to make the decision. I just want to be clear though, about just to clarify one part of the bill, or a couple parts. It doesn't just try to protect individuals who are minorities in the state from being pulled over. It would protect everyone. It would protect white Mainers. It would protect poor Mainers who are pulled over at an exceptionally high rate as well. It would protect everyone. And I agree with what Representative Morales said, which is that I think it would improve the relationship between law enforcement and the public by limiting pretext stops, because I think that relationship is harmed when people feel that they are being pulled over just as an excuse to investigate something that law enforcement has no evidence of. So I think this actually will help law enforcement in the long run. I hope I attempted to answer all of your questions, but the initial one about how do we determine the subjective intent of the law enforcement, it's going to be difficult, but I think it will help. I think it will help. And I think we can look at what law enforcement is saying, particularly given that body cams and cruiser cams are becoming the norm these days for any stop. Thank you.
Senator Searway.
Thank you, Madam Chair. Just another question to Mr. Pratt. I appreciate you saying this would work for everyone, and I was kind of concerned on how this was introduced, of saying that was for specific situations and people, and more so than everyone. And when in law enforcement, we're trained to deal with the situation and not who it is or whatever the specific things. And I don't even know what the definition of poor is, because poor in California and in some places would cover just about anybody in Maine. So I'm just saying that to me, it should be everyone. And do you agree? Do you agree?
Of course I do. And I think the bill does not specify language of any single group. And in the area that I live in, frankly, it would be largely, the area that I live in is, I think, 96.4% white, according to the last thing I wrote on the issue. So it would protect all Mainers, poor Mainers, rich Mainers, Mainers of color, every single person who is here. And I think the important part is to stop pretext stops for everyone, not for any particular group. I think, though, it is important, and I think what was stated earlier, that people of color are disproportionately stopped at a higher rate, and we shouldn't ignore that. But we also, but this bill would help protect that group that is already being affected at a higher rate, but it would protect everyone. It would protect everyone's civil liberties to make sure that that they are free from unwarranted government intrusion unless the government had, again, just reasonable articulable suspicion. That just means something that they can articulate, a suspicion that is reasonable. That is a very, very low standard. Thank you.
Representative Costain.
Thank you, Madam Chair. Mr. Pratt, my question would be, where are we getting data for traffic stops? Because familiar with law enforcement, I know a lot of agencies have no record of traffic stops. For example, the state police or the sheriff's office. So a lot of municipalities call their stops in, but the others don't. So where are we getting the data that you're coming up with?
Well, all of the data that I cited to is not Maine specific, and none of the data.
So why are we talking about data that's from out of the state of Maine?
Because Maine hasn't funded any programs to track data in Maine. I believe that there's a pending bill. I wish I could remember who sponsored it, because I feel like it's somebody on this committee, but I can't recall who has sponsored a bill to collect that data going forward. If we had that data, I would love to have it. And I would love to be proven wrong that Maine is the one state in the country that doesn't disproportionately pull over people of color or poor people. But the data is suggesting that every other state and nationwide that there is a problem makes me believe that Maine has the same problem. But I would love, if this legislature will support that bill, I'll happily come before you in 5 years and say that I was wrong, that Maine is different, but I am skeptical. So I would urge, I know we're not here on that bill, but I would urge passage of that one so we can have all of that information and have a frank discussion about what does it mean and how to proceed and how can we fix any problems that come from it. So, but I readily concede your point that we don't have Maine specific data, and that is a shame.
Yes, follow-up question.
Yes, you may.
So I've been a police officer for almost 40 years, full-time and part-time. And I can tell you in the central Maine area, I don't see what we're talking about. So, you know, I just don't see it. So I would have to see the data before I could support this bill that shows me that this is going on. And data from out of the country or out of the state of Maine absolutely doesn't apply in Maine.
Well,
thank you.
First, I appreciate you serving as a law enforcement officer so long. I greatly appreciate that. I wasn't sure if there was a question, so I'm just going to respond if that's all right, Representative Warren, or should I not?
Yes, please.
Again, I'm not really sure how to respond because we don't have that data here for Maine, but and I'm glad that you have not experienced that, because it's definitely that has not been my experience as a criminal defense lawyer, because I've seen it repeatedly done on the stand where law enforcement will admit that they pulled people over for pretextual reasons. I can't say that I've seen it done for people of color. These are all examples of poorer Mainers being pulled over. And I was appointed, I know that they are poorer because I was appointed on a court-appointed basis to represent them. And so they qualified as indigent. I've seen that admitted to multiple times on the stand. I've seen judges say there's nothing that they can do about it because the law of the land is that pre-step steps are allowed. But I don't think law should be made, in my humble opinion, from just based on our individual experiences. That's why we need the collective information that hopefully that bill that has been sponsored will provide us. But I would ask the representative to consider looking at the studies from other states and from nationwide and just want and think of, is there a possibility that that could be going on in Maine outside of the area that you have patrolled? So thank you.
Thank you. Representative Pickett, do you have another question?
Yes, thank you, Madam Chair. Yeah, just one more thing. Would you agree then, Mr. Pratt, that possibly we're getting the cart before the horse? maybe the other bill that you're speaking about is the bill that we need before we start, especially where we have, as Representative Costain said, the data. We don't have that here in Maine, and we shouldn't be basing on what we're doing here on what other parts of the country is doing and their specific needs. So would you agree with that, that maybe we have the cart before the horse when it comes to this bill?
I wouldn't be, just only because the data from all of the other states are so overwhelming. I've seen no data from any other state to suggest that this isn't the case. And I think, as someone testified earlier, I don't think Maine is immune from it. I would love to have the data because I think it would be the cherry on top for the argument. But every single study that I've seen, every single law review article, every single entity that has explored this issue suggests that it's a problem. And again, I would love to have the data, but I don't think it's necessary to go forward with this bill. I think we can rely upon our 49 other states.
Follow up, Madam Chair.
Yes, you may.
So then really what we're saying is that the data that's being used is not main data because we don't have it, but that data is what's the context of why we have this bill before us, correct?
I wouldn't say that the data alone is the reason we have the bill for us. I think we have the bill. For me, the reason that I would like to support it isn't necessarily because it affects any one group disproportionately to any other group. The reason that I'm supporting it is that I think the Wren decision from the US Supreme Court is not a good decision. I would urge this legislature to not allow police to pull people over or question them if they don't have a reason to do so. And that they are taking one minor traffic infraction to explore another issue. So I don't think it really has to do with whether or not minorities or poor people are being disproportionately affected. I think the real thrust of it is we don't want government intrusion unnecessarily. And so again, all we're saying to law enforcement is have a reason that you can articulate. I think that the information is informative and shows the urgency for certain groups that data provides, but I don't think that that is the compelling reason. I think the most compelling reason is we don't want overstepping by government entities. And I think pretext stops are overstepping for all people. I hope that answers your question. Thank you.
Thank you.
Any more questions for Mr. Pratt? Seeing none, thank you, Mr. Pratt.
Thank you, I appreciate it.
Others here to testify in support of LD 417? Yes, Ms. Rue, I wanted to pronounce your name right. Could you pronounce your name? I'm sorry. Oops, you're on mute.
My name is Suzanne Rudalevich.
Thank you for being here.
So, good morning, Chairperson Warren and honorable committee members. My name is Suzanne Rudalevich, and I am currently retired and living in Cape Elizabeth. I am testifying on behalf of the Anti-Racism Policy Committee of the Hope Gateway United Methodist Church in Portland. I don't want to repeat a lot of what other people have said. You've had a good discussion here, and you do have my testimony, written testimony. But I would like to emphasize that this LD does limit the intrusion of the police into any driver's world, but would certainly give greater protection to Black and brown drivers. I've heard this discussion of, well, is this true in Maine? And we've said that we don't have the data to be absolutely sure, but I would be pretty sure in that when I came to Maine about 20 something years ago, Maine was much whiter than it was now. I was doing criminal justice advocacy work, and I believe I was at the Muskie Institute. And as I'd come from Massachusetts and Connecticut, I said, okay, so not many Black people here in Maine. So who do you lock up?
And there was a pause, and they said, "Well, I guess it's poor white people, mostly in the north." Well, now the statistics that we do have, if you look at any of the statistics that we do have as to who is arrested, who is imprisoned, who is sentenced for longer, we know that all the figures are skewed, and the people who draw the short straw are people of color. So I don't have any reservations in saying that we are pulling over black and brown drivers in Maine more than we are pulling white people over. But I want to be clear that we are not here to impugn individual police officers or officers as a group. The intent of this bill is to address the system within which they operate and to ensure that the system is equitable. Being raised in the US has given white people a sense of presumed authority over those who are not white, which manifests itself in overreaching behavior when placed in a position of power. And most of our police officers are white. As whites, we often are raised to believe that we are more law-abiding, more moral, more everything good. We know that this is not actually true, but it's hard to erase these often unexamined injunctions of upbringing, which are embedded in this culture. Since it is clear that we cannot change our underlying assumptions on matters of race easily, we therefore need to make laws which will do a better job of controlling inappropriate behavior in those representatives of government to whom we grant authority over others. So I ask you to please vote in favor of LD 417. Thank you. I'm happy to answer any questions.
Thank you for your testimony. Representative Pickett has a question.
Yes, thank you, Madam Chair. Thank you, Mrs. Rudelovich. I probably murdered your last name, but I'm sorry. But in your testimony, I think, quite frankly, I think you have really laid out what is really a great example of this law, because you've, in your fourth paragraph, about halfway through, you say, "We have a recent example with a Maine state police officer who pulled a driver over for driving in the middle lane of the highway when he was not overtaking, and who was subsequently charged with drug violations." So the person is driving in the middle of the highway, which is clearly a violation of law, and which could mean that the person has a number of different things going on. He's pulled over by the officer, who would be derelict of his duty if he didn't do that, if he was following them. And then he found drugs in the vehicle. So what is he supposed to do with the drugs? Is he supposed to just ignore they're there because he pulled the person over for just the violation of the car being in the middle of the highway? And I'm not saying that, I'm not trying to be argumentative with you, ma'am. I think this is a really good example of what some of the dangers of having this bill could present to us. And you don't really have to answer it if you don't want. If you certainly can respond to it, but that's what I'm thinking.
Yeah, I mean, this is the example that that Michael Kabidi was giving about the Maine State Police. It's the same guy who the evidence was suppressed. But I mean, what we're saying is that if it was you or I driving down the middle of the highway and not doing anything else that was at all, peculiar, which apparently this guy was, the driver was not. I mean, we would not be stopped. I mean, it's very unlikely that you or I would be stopped. But as we know, it was a racial stop because of the evidence that he said, that it was, he said, "Oh, looks like a thug to me." And even though it was night, when many less people are, the pullovers are much more equal at night because it's harder to see. But he probably could see that he had dreadlocks, and that was a giveaway for him. And yes, I mean, there will be some crimes that go that go by, but he didn't know anything about that, and he wouldn't have stopped him if he was not black, that particular guy, because he admitted that. So yes, there will be some misses, but I don't think that is weighs more heavily than harassing people of color, which is what we are beginning to do. Well, this
Thank you,
country,
ma'am.
this country has always done, let's face it.
Other questions for Ms. Rudelovich? I know, I'm sorry.
That's all right. I've been called Mrs. Rude Lettuce when I taught nursery school, so it's all right.
I will not call you Mrs. Rude Lettuce, I promise. My question for you is the trooper that you're referring to, Trooper Darcy, who said those things, looks like a thug, etc.
Yeah, that was yes. It was in. I mean, I only read what was in the newspaper, probably like most people. But yes.
He received the Trooper of the Year award.
I believe so. Yes, I'm pretty sure that was in there too. Yes.
Thank you. Other questions? Seeing none, thank you for your testimony. Others here to testify in support of LD 417? Seeing none, those here to testify in opposition, please raise your hand. And I saw first DA Slattery, welcome. And then we have Ms. Graham from MMA.
Thank you, Representative Warren, Senator DeChambeau, members of the committee. I'm here today as a representative of the Maine Prosecutors Association. My name is Catherine Slattery, and I am the district attorney for Prosecutorial District 1, which is York County. While the Maine Prosecutors Association recognizes the seriousness of the issue being addressed today in LD 417, and we are willing to work on those issues, we nonetheless oppose this bill as written because of the severe impact it will have on public safety. As presented, this bill would prohibit an officer, for example, from taking any action where an individual has been stopped for a traffic infraction who it turns out is visibly intoxicated. The bill specifically states that all conduct must be related to the purpose that permits the stop, and the evidence of other criminal conduct may not be used. Similarly, in that same traffic stop, there may be evidence of human trafficking or domestic violence discovered that must be ignored. The constitutionality of motor vehicle stops based on probable cause that a traffic infraction has occurred is an established principle. The basis for challenging admission of the evidence seized from such a stop is a motion to suppress. The evidence must be shown to be lawfully obtained. The difficulty presented by this bill is that it identifies the subjective intent of the officer, quote, the sole purpose of the stop, as the basis for stopping any further investigation into suspected or observed criminal activity. Thus, the same driver, the visibly intoxicated driver, visibly injured or distraught victim is not properly subject of inquiry by the officer. The officer has to let the operator proceed, summons in hand for the motor vehicle offense in order to comply with this proposed law. How do you distinguish between a motor vehicle stop that begins as just that and blossoms into a full-blown investigation and one based on an officer's subjective intent? Representative Morales indicated that she's looking to set a policy. It's possible to craft, as other states appear to have done, a law which allows suppression of evidence obtained by a motor vehicle stop where it appears that the stop was racially motivated or motivated by some other improper motive. But that is not what this LD does. Its sweep is far too broad. And for those reasons, the Maine Prosecutors Association does oppose this bill and ask you to vote out not to pass.
Thank you, DA Slattery. Questions from committee members? Seeing none, thank you. Excuse me. Yes, Senator Lawrence.
Actually, Representative Warren didn't have a question. Kathy was my deputy district attorney when I was district attorney in York County, so I just wanted to say hello to her. I haven't seen her in a while.
Thank you. Okay, seeing no other questions, next on my list, I have Rebecca Graham from Maine Municipal Association, then Major Scott, and then Chief Mills.
Thank you, Representative Warren. I'd just like to start off by saying thank you guys for attending on Monday. Hope that you found it of value, but would appreciate your feedback if you have any as well. Senator DeChambeau and Representative Warren and members of the Criminal Justice and Public Safety Committee. My name is Rebecca Graham, and I'm testifying in opposition to LD 417 as directed by MMA's 70-member Legislative Policy Committee. Municipal officials believe that as drafted, not only does this bill eliminate a tool that's vital for law enforcement, it has a lot of unintended consequences, as you've just heard. And also will impact the officer's ability to identify issues of human trafficking, child abduction, and other violent crimes. As drafted, the measure could render any evidence seized from that vehicle fleeing from a violent crime scene where there's little or no information available regarding a suspect vehicle completely unusable. Municipal officials believe that the suppression process is already a robust system of checks and balances. And as we heard in that improper stop, that evidence was suppressed, which is exactly how it's supposed to work. Additionally, if an officer repeatedly has their traffic stops thrown out or suppressed, that's a red flag for the prosecutor's office, as well as for their leadership, that there is an issue with that individual. So while local leaders understand the reasoning and behind this introduction of this legislation, as drafted, the bill falls short of actually enhancing procedural justice culture, which has been statistically shown to actually reduce racial harm. The bill seems to point at a symptom and declare it the problem. So at issue are the perceived abuses of authority that feed distrust in police and erode legitimacy, which then in turn makes public attitudes towards police really, really poor. And the procedural justice principles are the theories that write that. And municipal officials support the use of the evidence-based ongoing conversations with this regard, not only to improve community respect for law enforcement, but also police officer morale. Municipal police are being encouraged at all levels to evaluate policies, training, and enforcement data for discriminatory practices. However, municipal officials can't support removing a tool for them that's largely used in communities for public safety. So for all of those reasons, we ask you to oppose this bill.
Thank you, Ms. Graham. Any questions for Ms. Graham? Seeing none, thank you for your testimony. Up next, I have Major Scott. Welcome.
Well, good morning, Senator DeChambeau, Representative Warren, and members of the Joint Standing Committee on Criminal Justice and Public Safety. My name is Major Brian Scott. I'm here today to testify on behalf of the Maine Department of Public Safety and the Maine State Police in opposition to LD 417. This bill would preclude an officer from the ability to stop a motor vehicle for a traffic violation if the officer suspected that an occupant in the motor vehicle had committed a crime unrelated to the reason for the stop. Per the bill, any evidence of a crime obtained from that stop would not be able to be used in any criminal proceeding. This bill would have a devastating impact on law enforcement's ability to do their jobs. This would result in a decrease in public safety in Maine by making it more difficult for law enforcement to prevent car crashes, and it would prevent officers from halting ongoing criminal activity that they uncover through the performance of their work. This bill would give greater protection to those in Maine who are suspected of criminal activity than those in the United States or the Maine constitutions do. If enacted, this would result in fewer crimes being prosecuted, less protection for law-abiding citizens who are or could foreseeably be victims. The United States Supreme Court in Wren versus the United States determined that as long as an officer has a legal reason to stop the vehicle, it is not in violation of the Fourth Amendment's prohibition against unreasonable seizures, even if the true objective for stopping a motorist was unrelated to the articulated reason for the stop. An example might be an officer on patrol at midnight on a holiday weekend observes a patron leaving a bar and gets behind the wheel of an automobile and drives off. The officer knows that many people leaving a bar at midnight on a weekend have consumed intoxicants, but this scenario falls short of probable cause to believe the operator is impaired. This might be the hunch standard that was discussed earlier. The officer notices that the vehicle has a taillight out and decides to stop the vehicle for that defect. Once stopped, the officer observes indicators of impairment of the driver and ends up, through probable cause, arresting the driver for impaired operation. So currently, this type of stop plays over and over again in Maine, and it's legal. However, this bill would make the conduct of the officer illegal. So instead of the officer being able to remove an impaired operator from the roadway before they endanger others on the road, they would have to wait to develop probable cause to believe the operator was impaired before they could stop the motorist. Waiting may very well result in the operator crossing the center line, striking another vehicle head on, and killing its occupants. Or an officer receives a report of a domestic violence assault where the suspect has fled the scene in a motor vehicle, but no description of the vehicle has yet been provided. While en route to the resident, an officer observes a vehicle speeding down the road and stops the operator for the violation of exceeding the posted speed limit, but is also thinking there is a possibility that the operator may be the one that's fleeing the domestic assault. Upon investigation, the officer determines the operator is the suspect and was fleeing after beating his spouse, leaving her with serious injuries resulting in hospitalization. The offender admits he committed the assault and the officer arrests the suspect. Under this proposed bill, the officer's conduct would be in violation of the law, and any evidence obtained as a result of that stop could not be used against the suspect. Another one would be an officer working in an area where there have been cases of human trafficking, observes a tractor trailer pull into a truck stop and stop momentarily, just long enough for a young woman to get out of the car. Out of the tractor trailer. After hearing the driver yell something out the window, the woman jumps back into the tractor trailer and the tractor trailer leaves. Now, there may be a reasonable explanation for this incident, such as a parent yelling at their daughter to get back in the truck. Or it might be that the young lady is in danger and needs immediate police help. The officer follows the tractor trailer and observes the vehicle merge onto I-95, but it fails to yield the right-of-way to a vehicle already occupying that lane. The officer stops the tractor trailer for the violation of failing to yield to the other motorist and later determines that the young lady was in fact kidnapped and is being used in sex trafficking. Once again, the officer's conduct would be illegal, and the suspect would walk free from those charges related to the crime, but may be summoned only for failing to yield. I am confident that no one here today wants any of those things that I just mentioned to happen. But the fact is, that is exactly what this bill would do. I did discuss these concerns with the bill sponsor, Representative Morales, who assured me that that is not the intent for a bill. However, it is my opinion that'll be the result. So for these reasons, I strongly urge the committee to vote ought not to pass on this bill. And on behalf of the Department of Public Safety, the Maine State Police, I thank you all for your time. I'm happy to try and answer any questions that you may have.
Thank you, Major Scott. Any questions? Yes, Representative Pluker.
Thank you, Madam Chair. Could you just for a second explain to me the idea of reasonable articulable suspicion, which was an idea that was explained to us previously?
Sure, Mr. Pluker, that's a good question. So from a law enforcement training perspective, reasonable articulable suspicion is a pretty low standard, and that was mentioned earlier by Mr. Pratt. That standard is that you have got to be able to articulate, based on your training, education, experience, and the observations that you're currently making, that a person is committing or is about to commit a crime or another violation of law.
Follow up, Madam Chair.
Yes, please.
So in reasonable articulable suspicion wouldn't exist in some of the examples that you were laying out for us earlier. I was having a hard time understanding if somebody could reasonably articulate suspicion that somebody was being kidnapped, that would be insufficient cause for pulling somebody over. Thank you.
Representative, thank you for that question. All of the examples that I provided, the way that they were worded and constructed was careful. I stopped short of reasonable articulable suspicion in every scenario that I just described. Those are hunches. Those are something that an officer believes could in fact be occurring, but does not yet have the ability to articulate based on the fact pattern that they just observed, or the suspicion of the fact pattern that they observed, that a crime is being committed. In the incidents of the truck and driving off, there could be many reasonable explanations why a young lady would jump out of a tractor trailer and then quickly back in. But a police officer might have a hunch that there could be something more nefarious going on than a parent scolding a child for getting out of the tractor trailer and yelling at him to get back in. So no, the fact pattern that I described, in my opinion, does not rise to the level of reasonable articulable suspicion. It's a hunch. It may be suspicion, but there is a difference in my mind between suspicion and reasonable articulable suspicion.
Major Scott, could you give me the definition of the term again? I hear that you're saying there's no, in your mind, what matters for us is obviously when someone goes before a judge, what the legal term is. I'm finding it interesting. So could you explain the term again? Reasonable articulable suspicion.
Sure, Representative Warren, I can. The exact legal standard is established by case law, not off of any one particular state statute that I'm aware of. So it's based on the officer's training, education, experience, where they're able to articulate from a given set of facts or circumstances that there's reason to believe that a person is committing a crime or is about to commit a crime. When it comes to investigatory detentions, then we might have to operate under something that's closer to a Terry stop than we would a probable cause stop. So there is a difference. I'm speaking of the reasonable articulable suspicion, where my feeling is you have to have more than a mere hunch, which again, in the examples that I provided, I think a reasonably cautious and prudent officer would have a hunch that there was suspicion of OUI in the first example, or might have a hunch that the person who is speeding in the proximity of a location where a domestic violence assault had occurred, but the officer doesn't have a description of the vehicle. So you can't quite get to that reasonable articulable suspicion, but you sure have a hunch this may be the person. And in the final example, I think an officer with training in human trafficking would have a hunch that there was a crime occurring, but not a reasonable articulable suspicion standard, because I can't say with any degree of certainty, and not that reasonable articulable suspicion requires certainty, but it's reasonable. And I have to be able to articulate that belief. And to say, because a young lady jumped out of a tractor trailer and then back in after a short period of time is a reasonable articulable suspicion of a crime of human trafficking or sex trafficking or kidnapping, it really falls short. That's the reason why I selected those examples.
Thank you. I'm having a lot of trouble with that. So I'm going to want to explore that more at the work session. And specifically, I'm going to be looking at the definition of hunch versus suspicion, because those sure sound like suspicion to me. So I'm going to be really interested in those examples. And I just have a couple more questions, Major Scott, and then I see that we also have Senator Searway. My question is uniform crime reporting data. Does that also include traffic stops?
Representative Warren, it does not, unless there has been also a crime associated with that traffic stop that results in a requirement for fingerprinting and what they call an ATN, an arrest tracking number, that gets submitted to the State Bureau of Identification so that we could compile that information. So most traffic stops don't fit that category and will not be part of the UCR or SBI records.
How are traffic stops reported? How do we know in Maine what's going on with our traffic stops? How are they reported?
So Representative Warren, that is a fantastic question. And the answer is traffic stops, generally speaking, are not reported in Maine. Traffic summonses or violation summons and complaint are all submitted to the Maine Judicial Branch. So they go to the Violations Bureau in Lewiston, where they would be a centralized repository for traffic stops that result in a ticket. Traffic stops that don't result in a ticket are handled in various ways throughout the law enforcement agencies in Maine. There's, I think, 164 or so law enforcement agencies in Maine. They all have different ways of capturing that data, if they capture it at all. I can only speak to the Maine State Police. Our traffic stops are generally, if it's a warning, are documented on a paper stub, so to speak, and we turn those in at the end of the month to a supervisor, and they're saved. They're not submitted to any centralized repository. They don't collect a lot of the data that this committee might be interested in, such as LD 132 that went in front of Judiciary last week, would ask us to collect. So there is no centralized repository anywhere in Maine for traffic violations that don't result in a summons. And I can tell you the majority of traffic stops result in a warning in Maine, not in a ticket. So most of the data is not collected on.
Would it be helpful to you as the major of the Maine State Police to have that data? I suspect you're going to see this bill again, or we pass it this year. Would it be helpful for you to have that data?
So Representative Warren, the answer is yes. It would be helpful now. In the past, it wouldn't have been helpful. For the Maine State Police, as we have not ourselves become aware of a significant problem when it comes to any profiling from our agency. Now, having said that, the decisions that we make on enforcement aren't based on geographical or other types of information such as race or age or orientation, or fill in the blank. We base it on the totality of the circumstances for the violation itself. So for us as an agency, the data, whether someone was a person of color or not, or a male or a female, or their age, just wasn't important to us as an agency because they weren't factors in our enforcement. However, now that this issue has come up several times, to include 2 years ago during the 129th, which actually is what LD 132 is an act to do. It's to implement the findings or recommendations of the Attorney General's office regarding data collection. And that was as a result of the 129th legislative session having a resolve for that to be studied by the AG's office. Now that we're being asked questions by folks such as yourselves and members of the public, we feel it is important to have that information because we would like to be able to answer that question. However, the Maine State Police stops based on reasonable articulable suspicion as a minimum standard, probable cause a little higher standard, about 75,000 motorists annually, and another 100,000 or so commercial motor vehicles, regulatory in nature, meaning without reasonable articulable suspicion, because we're enforcing the federal motor carrier safety regulations. With that amount of stops, it becomes pretty apparent to us that we need a technology solution in order to be able to capture that data, catalog it, and run reports against it. And it is relatively expensive. So we have started looking at some options. As a matter of fact, we presented an option to the Judiciary Committee last week on a way that Maine law enforcement as a whole might be able to collect this data moving forward so that it would be useful for committees such as yours and Judiciary as you make public policy decisions and laws for us to enforce.
Very helpful. Thank you very much. I see Senator Searway with a question.
Thank you, Madam Chair. Good afternoon, Major. Just got a question on, and I think you touched on it a little bit, but the longevity of a law enforcement officer lasting in a career with this type of law taking place. I would think it would be very difficult for him or her to survive through 25, 30 years in law enforcement as a career, and probably going to lose a lot. And I just wanted you to touch on that and why it would affect them.
Well, good afternoon, Senator Searway, and thank you for that question. I think it's an important question. I've certainly talked with a lot of law enforcement officers about the implications of this bill. The frustration that would come out of it is the bill would, in my opinion, ask an officer to do the job to prevent crimes, to prevent those from being further victimized in the state of Maine, to keep Maine a safe state. That's what we all want. But we feel that you would be asking us to tie one hand behind our back or place one hand behind our back with a handcuff and then asking us to go into a fight. This bill, as written, would limit our ability to do our job. Well, we want to do our job because we want to protect people. We want to save people from becoming victims. And this bill would not allow us to do that. So the frustration that I hear would mount was, how can I protect people if they're going to allow the statute, going to allow for suspected criminals' rights to be more empowered than the rights of those victims that we're trying to protect from the drunk driver, from the domestic abuser, from the kidnapper, or a person engaged in human trafficking. So this is a difficult job, and I'm not complaining. Those of us that do it and last a career in it feel it's a noble profession, and we're happy and we're honored to be able to do it. However, we don't want the job more challenging than it already is. There is a high burnout rate for law enforcement officers. not as much in Maine, but the national average of a career for a police officer is about 5 years. The average life expectancy, which I know is not related to your question, for a police officer is 57 years of age, or 22 years younger than a member of the general public, because of the stressors, hazards associated with the career. Making a police officer's job more difficult is only going to lead to more recruitment retention problems and will force more officers out of this profession out of fear that they won't be able to adequately do their job. And I am not overstating this. The bill as written will have that impact, in my opinion. Thank you, Senator.
Thank you.
Seeing no more questions for Major Scott, next on the list we have Chief Mills, and then I do see that Sheriff Young also is going to testify. Welcome, Sheriff. So you're up after Chief Mills.
Thank you, Representative Warren, Senator DeChambeau, and esteemed members of the Joint Standing Committee on Criminal Justice and Public Safety. My name is Jared Mills, and I'm the police chief here in the city of Augusta, and I'm here today on behalf of the Maine Chiefs of Police Association. LD 417 would prohibit a law enforcement officer from stopping a motor vehicle for an offense in violation of existing Maine law if the officer suspects the driver or occupant is committing a separate, more serious act in violation of law in order to further investigate the totality of the circumstances. If an officer should do this, any evidence obtained that is not directly connected to the reason for the stop would be thrown out. We find this very puzzling. Why is it in the public interest that a law enforcement officer may stop a vehicle for a motor vehicle offense only to be prohibited from making further enforcement action on any other offense detected after the initial stop? You have heard a number of examples today of how pretextual stops are used in the legitimate pursuit of wrongdoing. I could provide many other examples, but that is probably not necessary. Proponents of this bill apparently believe that what they are calling pretextual traffic stops are somehow nefarious. Dictionary defines pretext as an action that is meant to conceal or hide the real intent of an action. However, this bill goes well beyond preventing law enforcement officers from hiding their real intent. Rather than outlawing all pretextual stops, which the United States Supreme Court has determined to be constitutionally sound, we believe that a better approach is to examine the intent of an officer who may engage in a disproportionate amount of these types of stops, a procedure that would be facilitated by the collection of data on vehicle stops. For example, we know the drivers who are members of an ethnic minority, especially persons of color, sometimes believe they are targeted for pretextual stops because of their race. This is known as racial profiling, and it is already illegal for an officer to engage in this type of activity. Other legislation before you aims to determine the extent to which racial and ethnic profiling is a problem in Maine, and we, as police chiefs, support that effort. But to outlaw all pretextual stops would remove from law enforcement a legitimate and effective means of apprehending those engaged in criminal activity that is not always readily apparent. Simply put, this bill would make our communities less safe by compelling police officers to simply walk away from ongoing criminal activity occurring in their presence, and even worse, allowing that criminal activity to drive away, putting everyone else at risk. We urge you that you give LD 417 an ought not pass report, and thank you for listening, and I will entertain any questions that you have at this time.
Thank you, Chief. Any questions for Chief Mills? Seeing none, thank you. And next up, we have Sheriff Young. Welcome.
Yes, good afternoon, and thank you, Senator DeChambeau and Representative Warren, esteemed members of the Joint Standing Committee on Criminal Justice and Public Safety. My name is Robert Young. I'm the sheriff of Piscataquis County, and I'm here today on behalf of the Maine Sheriffs Association. Maine sheriffs met to discuss this bill, and our unanimous position is to oppose LD 417. The Maine Sheriffs Association Legislative Policy Committee reviewed this bill, while recognizing the motivation of this committee is to ensure the safety, well-being, and fair treatment of all Maine citizens as your collective priority. This bill has the potential to cause significant harm to the people of Maine. Maine sheriffs are committed to protect. In essence, this bill would prevent a police officer or deputy sheriff from investigating many serious crimes unless clear evidence was present unrelated to a traffic stop. Examples of crimes this bill is mandating law enforcement ignore would include human trafficking, drivers operating under the influence, domestic abuse, theft, and countless others that jeopardize public safety. Passage of this bill would serve only to have law enforcement look the other way when faced with these crucial and life-threatening circumstances. In June of 2020, the Maine Sheriff's Association stood with Maine Chiefs of Police, the Maine Department of Public Safety, and the Maine Prosecutors Association to deliver a joint statement that included, quote, "As community leaders, we are all accountable for the actions of our police officers. We must continue to build trust and follow best practices. We recognize that change starts with us. We embrace and honor this responsibility," end quote. We stand by this statement and look to collaborate with this committee and its members to achieve those best practices. LD 417 is not the answer. We strongly urge this committee to unanimously vote ought not to pass. Thank you for your consideration, and I'd be pleased to answer any questions.
Thank you, Sheriff. Yes, Senator Searway.
Thank you, Madam Chair. Being sheriff, and I know, you know, there's the Sheriff's Association. What do you feel, Sheriff Young, about the stress that is put on your officers because of this bill? Do you think it would put stress on them and their families?
I think it would have a, yes, it would add a stress factor. It would add a chilling factor to trying to enforce the law and trying to protect their communities. You know, if every time you make a traffic stop, you're second guessing yourself, if somehow this is going to be turned to work against you, that has a chilling effect. So I would say it would, yes.
Thank you.
Other questions for Sheriff Young? Seeing none, thank you, Sheriff. Others here to testify in opposition to LD 417? Anyone here to testify neither for nor against LD 417? Seeing none, I'll close the public hearing on LD 417. Thank you. And for the committee, we get a little bit of a break. Next up is 2 o'clock today. I wanna, before we go anywhere though, I'd like to make sure that my co-chair doesn't have any information to add, or that Jane doesn't have anything to add. Yes, Jane, please.
Thank you. I just wanted, I did get a note during the morning from John Pelletier from CLAC, who was in another committee, and CLAC had not had an opportunity to review LD 417. They are hoping to do that and to be able to assist the committee. Thank you.
Thank you, Jane, and thank you for making that announcement, because I have failed my job of saying, do people need additional information on any of these 3 bills for the work session? From Jane, and I will start off. Jane, I know that we have some of this data, and I think the point was well made that we're lacking in a full arena of this data. But could you bring in the information from the Council of State Governments Justice Reinvestment team? They gathered some of this data last session, and wherever else we have some of this data for the work session, that would be helpful. Let me just make sure. Other folks who would like data for the work session or information ahead of the work session? Senator Searway.
Yes, if there was any states that had this law passed, what the the numbers of law enforcement officers lost because of this bill. Because I think that this would definitely cut our police force down quite a bit.
The other thing, Jane, for Representative Costain's bill, because as I said earlier, I know what his intentions are, which is to make sure that this participation in public works was voluntary. But I also trust when attorneys come before us and say that they're just want to make sure the legal language says that. Can we just get an opinion on that, or however we go about doing that? I just want to make sure that his goals are met there. Yes, Representative Costain.
Thank you, Madam Chair. I think when we do the work session, possibly we will have a revision of the bill with, we'll work with Jane to try to come up with making sure that at least voluntary is in there with Sheriff Morton's amendment as well. So we'll work with Jane on that and hopefully bring that back so it's satisfactory to everyone. Thank you.
That sounds wonderful. Thank you. Anyone need anything else before the work sessions next week? Yes, Jane.
I just want to bring to your attention that the work sessions on these were, because of the budget, they're scheduled for Monday. I'm not sure that seems very realistic with regard particularly to the last bill we heard. Do you want to keep them, all three of them, still on Monday?
Sometimes it's helpful to begin the conversation, but I'm open to what other folks have for thoughts on that. Senator DeChambeau, do you want to weigh in on that? No, okay. Let's start them just because I know folks have put them on their schedule, but we amongst each other will know that we'll probably end up tabling, especially this last one we just heard. I think we're going to be gathering some data. And I also know that Representative Morales has had conversations with a bunch of folks that spoke and people that want to work with her on improving the bill or making changes to the bill. So we do want to have more time for that. But let's at least kick off the work on Monday, if that makes sense. Anyone else? Okay, so we're back together at 2 o'clock with Dr. Ryan Thornell, who's the Deputy Commissioner, to talk about the healthcare contract, which has recently gone out to bid for the Department of Corrections. All good? Okay, everyone have a nice long lunch break. Thank you. Bye.
Oh, okay. Did you see me? What the hell are you doing? You're gonna go away. Yeah, but did you see me? I pulled up my pant leg and stick my leg out, you know?
I was not, I'm ignoring that. Fucking people.
I just thought, you know what? It's such a nice day. I'll just walk over.
No, it's a beautiful day.
Yeah.
Shelley,
Go to Augusta this morning. I just kind of rode around. I came back to the school.
yeah, she's muted herself now.
Good afternoon, Dr. Thornell. Thank you. Good to see you.
Good afternoon. It's great to see you. Thank you.
We'll let folks come on in before we get started.
Sounds good. Thank you.
Charlotte, I don't know if I'm gonna get shorted out again. I don't know what it is that's gonna, look at that. Can you hear me?
We can hear you.
Yes, we can hear you.
Charlotte, can you hear me?
I can hear you, yes.
Okay. Can you see me?
I can see you. It looks like you may be.
I may. What? I'm getting a notice that's saying that my internet is unstable. I thought they meant me, but no. So I don't know if I'm gonna lose you back and forth. If I do, you just have to pick it up, okay?
The only thing we did say
Can
was
you-
about why we have this.
Does
meeting.
anybody, can you hear
Why
me?
we're having this meeting, we did.
We can hear you, Senator. If you turn your
Yeah,
camera
yeah.
off,
All
you
you
might
said
have
was-
more
All you said
stable.
was, why are we giving them another hour and a half? Right.
Your folks in the committee room,
Sharon,
you
I
weren't
can't-
muted.
Representative Warren and Senator DeChambeau,
I did get an agenda from Dr. Thornell this morning. I mailed it out to everybody. In case people haven't had a chance to see it, do you want me to share it for just a few minutes before we begin?
An agenda? Those usually come from the chairs. Say more about what this is. Is it just who's here today?
Well, yes, and their plan for who would be speaking about what, when.
Wonderful. We'd love to
Okay.
see it. Did all the members get it in their email?
Yes, I emailed it out midday.
Wonderful.
But I'll
Yes, we
just
did.
I'll share it right now and then I'll take it down unless you want to keep it up.
No, that sounds great. Thank you for doing that. And I'll look in my email as well. Great. Okay. Senator, I think Senator DeChambeau is having some technology issues. So let me welcome you all. Thank you so much for joining us today. Dr. Thornell, did you want to start and introduce everyone that's with us, or Commissioner Liberty? I open it up to whichever one of you would like to start. Thank you both for being here.
Well, thank you for having us, Representative, and good afternoon, Senator DeChambeau, Representative Warren, and distinguished members of the Criminal Justice and Public Safety Committee. I'm Ryan Thornell, the Deputy Commissioner of the Maine Department of Corrections, and it's a pleasure to be with you all this afternoon. I appreciate the invitation to speak with you all and provide what will be a briefing on the healthcare services of the Maine Department of Corrections. And what you see in front of you, or what was just in front of you, which is just a draft kind of plan for us for this afternoon to make sure that we're able to cover all of the topics that we receive questions on. Certainly just an opportunity for us to make sure we have a fluid conversation and make sure all of your questions and concerns are addressed. Earlier this week, as you know, I received the questions compiled by the committee regarding the healthcare services, behavioral health services, and other components of medical within the Department of Corrections. So what we've done is prepared a briefing for the committee, specifically addressing all of the questions, but also providing additional comprehensive information for you all that really fills in different areas that weren't necessarily specified in the questions. But it's our hope and plan that we proceed with the briefing and give you this overview and response at the same time, and then hopefully allow for questions that may come up. And I present it in a way of a briefing because there's so much of what we do on the health services side that is really intertwined across medical to behavioral health to treatment services. And so as we're all speaking this afternoon, I think it will hopefully be much more of a fluid briefing and fill in all of those different gaps. And then, of course, allow for questions and any other concerns that come up. So with that, the briefing will consist of information from me, as you all requested, but I've also invited a few guests that I'd like to just real quick draw attention to. And then as we go, they will provide more background on themselves. But along with me, we have our regional medical director, or in other words, our chief medical officer, Dr. Razi Ali. He is on the screen. We also have our behavioral health director, Dr. Robin Hodges. She joins us. Additionally, as you noted, we have Commissioner Liberty on with us today, as well as Dr. John Newby. Dr. Newby is the regional vice president for WellPath Maine. He serves really in the administrator sort of role over all of WellPath Maine and the services you're going to hear about today. I'd like to kick us off and begin with a few comments and just pieces of information regarding the contract for health services overall. And then we can dive into more of the specifics from those individuals with me. So the Department of Corrections is contracted and partnered with WellPath, which was formerly Correct Care Solutions, as some of you might have known them in the past. And this contract and partnership has been in place since 2012. And as noted in the questions, and you'll learn a little bit more about throughout this briefing, the contract size and scope has really changed and expanded at various points since 2012 as the services and the needs of the department have changed. A couple of examples would be the intensive mental health unit coming online in 2014, different expansions and modifications to substance use disorder treatment services, which you'll hear about from Dr. Hodges in a little bit. The addition of medication-assisted treatment services, which again, you'll hear more about. But those are just a few examples of changes to the contract size and scope over the last several years. The contract overall currently provides for comprehensive healthcare services. And so what we're speaking about today is really everything that falls under that umbrella, including medical services, psychiatric services, behavioral health services, substance use treatment services, and everything else that you would find in between those various categories. And I'm happy to report, and I think you'll learn throughout the afternoon, the partnership with WellPath has really been an effective one. And it's also been one that's very collaborative, but also very accountable to the department and to the state. And having this partnership and the WellPath Maine team has provided us access to really a national network of resources and placement opportunities for our residents that we previously did not have. One of the partnerships I want to draw attention to is the partnership that we've had during COVID-19. And as you've heard from Commissioner Liberty and myself in a few other briefings, our COVID-19 response has been as aggressive and effective as you could ask for in a correctional environment. And this is no doubt because of the partnership we have with WellPath and the healthcare services that are provided. I'm happy to report, as we are in 2021, that the positivity rate for the state of Maine Department of Corrections in January was 0.28% in our resident population. And currently in February, that positivity rate is 0% in our resident population. The other note I want to make, just as we enter into this, is just a reminder, if I could, that the department is currently undergoing a competitive bid process. For those who may not be aware, for our healthcare services, the contract has come up for rebidding. And so that process is currently underway. And as I'm sure all of you are aware, it's a very formal process. And I want to just make sure that as we provide information today and interact, that we respect that process in our responses and the information we are providing. And so I just wanted to make a note of that in case anybody was not familiar with that process currently being active as we speak.
Dr. Thornell, could you just let us know what the date is for the closing or just some dates around this?
Absolutely. So the request for proposals has closed, and the proposals were received approximately 2 weeks ago. And so at this stage in time, we're in the proposal review process and scoring process. And so we have a team assembled that is actively reviewing those responses, completing all of the contract and procurement requirements, doing all the follow-up communications, and then there will be a decision made. We would expect in the early part of March to when that decision would be formally made, and then we'd proceed with the next steps. And the contract will be slated to start July 1 at the start of the fiscal year.
Thank you.
So if I could, I'll go into just talking specifically about some of the contractual questions that were presented to us, and hopefully provide that information and some more to fill in some gaps that may be there. The WellPath contract for services, as I mentioned, has been amended and expanded at various points over the last 10 years. And really, I want to just make reference to the expansions have been the result of antiquated external services from previous providers, previous administrations, previous, what was thought to be best practices. And as the department has continued its partnership with WellPath, we've identified where those services need to be enhanced, replaced, brought into 21st century evidence-based practices. And so many of the amendments and expansions reflect that. As I mentioned, in 2012, WellPath did take over the contract. Prior to WellPath, Horizon provided the healthcare services for the department. When WellPath took over, the contract was initially budgeted for $20.7 million for an annual basis. It has since expanded, as I mentioned, including the creation of the intensive mental health unit, which is nearly $3 million per year for operation, and that came online in 2014. We have developed the assisted living unit at the Mountain View Correctional Facility. When that facility transitioned from a juvenile facility into an adult facility, one of the specialized units that was created there was that assisted living unit, which you'll hear more about from Dr. Ali here shortly. We've also had increases in the contract due to changes in pharmaceuticals. One example of that would be recent developments in the treatment of hepatitis C and the prescription drugs that are utilized in that treatment that were not previously available, and the costs associated with those. I also mentioned, as you all are aware, in 2019, we implemented medication-assisted treatment services that the department had not previously had in place. And so those come with additional costs, which we will also be speaking about. And then again, the expansion of different treatment programming that either were provided by other providers previous to the contract or are new, things in the substance use disorder treatment services and the like. In the current fiscal year that we're in right now, the contract is budgeted as $26.8 million. And so those increases that I mentioned are what take us from the initial contract amount to where we are at today. And the other point I want to just mention that many are not aware of when we're speaking about this contract is that the contract with WellPath is what we call a pass-through contract. And what that means is that the monthly payments that go to WellPath for these services are directly for invoiced and delivered services. And we have a quality assurance process in place to make sure that that's what we are paying for, is those invoiced and delivered services. So it's not just one bulk rate that we pay every single month, regardless of what occurs. It's, again, what we consider a pass-through contract. Additionally, I want to just mention that in many cases, the services provided are part of responsibilities of multiple positions and teams, and they're not cleanly assigned to one housing unit or one specific program. And I reference this, for example, the assisted living unit was one of the topics that was asked about in the questions. That's located up at Mountain View Correctional Facility. And the assisted living unit is a tremendous resource to our department and the staff medically and with behavioral health staff. But those staff are shared across the Mountain View Correctional Facility. So they're not assigned 24/7 to the assisted living unit. And so because they're not assigned directly to that unit, we don't have one specific budget for the assisted living unit. We have a budget for healthcare services at the Mountain View Correctional Facility. And you'll be hearing more about the staffing ratios and things, both in the medical side and behavioral health side. The contract also includes transportation costs, which are part of our offsite emergency room and specialty service costs. And I know that was also something that has been discussed previously and was referenced in the questions. Offsite services make up approximately $1.3 million of the medical contract. And these transportation costs and reimbursements are paid at main care rates. Of the budgeted amount, approximately $90,000 annually goes towards these transportation expenses for emergency visits. And those specifically cover things like ambulance service costs. And those vary from year to year, depending on our population, depending on the type of situations that we encounter, depending on the type of ambulatory response that's requested. Those vary. And, I can tell you that during the current fiscal year to date, we have conducted 178 emergency room trips, 93 of which were conducted via ambulance. And at the start of 2021, January 1st, the reimbursement rates increased. And so we are now paying at those increased rates. And so I'd like to now introduce Dr. Razi Ali, who, as I mentioned at the beginning, is our Regional Medical Director. In this role, he oversees all aspects of healthcare services for the department, to include medical and psychiatric services. Dr. Ali joined us in the fall of 2020, and we are excited to have him overseeing medical care for MDOC. He's really a true professional, a top-notch clinician. Dr. Ali, I'd welcome you to provide just a brief background of yourself to the committee, as they're unfamiliar with you, and then please just go into an overview of medical services for us. Thank you.
Thank you, Deputy Commissioner Thornell, Chair DeChambeau and Warren, distinguished members of the Criminal Justice Public Safety Committee. Good afternoon. My name is Razi Ali, and I'm the Regional Medical Director of WellPath here for the state of Maine. I would like to thank the Criminal Justice Public Safety Committee for inviting the DOC to update on the current status of our medical care that we provide our residents. Before we begin, I'd like to give you a lens into who I am as a person, as this is the first time that we're meeting. I am an internal medicine physician who trained at George Washington University. While there, I did a program in health policy that really gave me a lens into value-based care. I started my career in hospital medicine and then gradually changed into the value-based care system with Anthem and CareMore, providing medical care to Medicare and Medicaid beneficiaries. I wanted to have a broader impact on my community to help vulnerable populations and be a part of social and racial justice. And that actually led me to corrections. When I came into corrections, I didn't know WellPath versus Horizon versus any vendor, but I soon learned that WellPath's values in taking care of the patient matched my own values. And as I spoke with senior leadership, they introduced me to the unique relationship here in Maine. I chose to come to Maine because of this, and that is alignment. Alignment from the governor to the commissioner of health, to the commissioner of corrections, to the deputy commissioner, health services coordinator, but also alignment between Maine's DOC and the medical vendor. They are intertwined in helping care for these residents. And since I have come this past fall, what I can say is we provide comprehensive, integrated, compassionate, coordinated care while collaborating with our stakeholders. We provide care in various settings, but they include medical, behavioral health, dental, optical, palliative care, rehabilitative services in the way of physical therapy, and coordination of transitional care. We have the ability to be dynamic and flex according to the acuity of our patients, to the situation, and to the needs of our client. For example, in our medical world, we have the infirmary where we can give IV antibiotics, diuretics, closer monitoring and nursing care for those that are more acute or returning from the hospital. We have collaboration with health systems for ER and hospital care. And we also have collaboration with those health systems for specialty care and specialty services on the outpatient setting. Our medical services also include our assisted living unit, which is a housing area for our more frail residents who are medically complex and that need assistance with our activities of daily living or potentially additional nursing care. Our unit treatment team is evaluating our residents from our nursing staff to the input of correctional officers to the health services administrators. When that resident is noted, a review process is begin and a referral is made to the health services coordinator within DOC, who then reviews with me these individuals and if they are appropriate for our assisted living unit. It's then passed on to our classification system in the DOC, and those individuals end up transitioning. So very proud of the ALU at Mountain View. It is because of this deep collaboration that we have with Maine's DOC that we've reached such great measures when it comes to COVID. We are the best in the nation when it comes to the number of COVID cases within our prison system. We are second in COVID deaths, second best, I should say. And these wins are huge and speak to how we prepare, respond, and take care of individuals within our facilities. When it comes to behavioral health, we are extraordinarily unique in that we have our intensive mental health unit, where we can help care for those individuals with severe mental illness. We have access to therapists, psychiatrists. We have the ability for treatment for substance use and opioid use disorders. I'm incredibly proud of our work in MAT, incredibly proud of Dr. Hodges, our director of MAT, Melissa Caminetti, as well as Deputy Commissioner Thornell for pushing and being so progressive when it comes to MAT and providing this to our residents. When it comes to dental care, we've known that dental care equals systemic care, and we've built an operatory to help care for our residents. We have a denturist, and we've even brought outside specialists into our facilities. We have an oral surgeon that comes in that helps care for our patients. Some may joke that it's actually quicker to get an appointment with an oral surgeon within the DOC than it is outside of the DOC. So with that, let us understand that we are here to provide care where care has not been given, and also to provide safety. Let us be honest, let us be humble, and let us be bold in leading the nation in the care for our correctional residents. These services that we provide are not just to our general population, but they are to our women's as well as juvenile residents as well, and encompasses so much. We have far to go, but we have come so far. And I thank everyone. Thank you.
Dr. Ali, can I ask you a question?
Please.
Just wondering about sort of the structure, the organizational structure and of WellPath in Maine. And WellPath is still Correct Care Solutions, right? Nationwide? Are you the same organization nationwide?
Yes. Yes.
Yes. And you're in 35 states, is that right?
Correct.
Correct. Okay. And in Maine, we have 1,700 residents, is that right? Under your care?
Correct. Correct.
And how, so under you, you're the medical director, and under you, how many physicians do we have? How many, can you just kind of lay that out of like, who are the staff, the team?
Right. So yes, so we have a group of physicians and nurse practitioners throughout all of the correctional sites. We have right now 6 providers that are providing care, but I would not get hung up on the number because we have the ability to flex using telehealth. So we use telehealth and our providers nationally to help provide care if we need more bandwidth to take care of residents. So it's not just who we have boots on the ground here, but it's also the use of telehealth, not only in the medical side or on the medical side, but also on the psychiatric side as well.
Or are you thinking I'm saying that's not a lot? I'm just asking for what the organizational structure of your team here is. That's great that you have telehealth. I think everyone's moving in that direction. That's great. So you have 6 medical providers that are made up of physicians and nurse practitioners?
Yes, ma'am.
Is that what you're saying?
Mm-hmm.
And then, sorry, I didn't mean to stop you. Keep going.
No, that's it. Yep. We have 6 medical providers. And we also have, dentists, and we have a physical therapist that comes in, but we also contract on the outside for physical therapy as well, where they can go to outside services.
Dr. Ali, would you also provide just an overview of each site having a health services administrator, director of nursing, and the nursing staff that makes up that team?
Yes. So at each of our sites, we have a health services administrator who's the administrator for the medical side for us. Then below that person, we have our director of nursing who's providing all the nursing oversight and care for our residents. We then have nurses, RNs and LPNs that are not only taking care of individuals day in, day out with passing medications, but also doing sick call, triaging individuals, doing new intakes, elevating using our protocols to our providers if an individual needs to be seen. And that's at each of our sites.
And I see Representative Fluke. Oh, whoops. Do you have another question, Representative Rounds?
I was just trying to get a sense of like how many people are what is the team made up of? How many people in WellPath in Maine? I understand you use telehealth and stuff. So I've counted a dentist, physical therapist, health service administrators in every site. Would that be like 6?
So
and then nursing oversight and RNs and LPNs that probably aren't included in the 6 providers for that are nurse practitioners and physicians.
Correct. So, I can come back with the exact numbers of RNs and LPNs that we have for our entire enterprise.
Oh, that'd be great. Thank you.
Yeah.
I didn't mean to put you on the spot on that know all that today.
It's fine.
Representative Pluker.
Thank you so much. Getting to that idea or question about staffing, do you have a sense of how long some of your wait lists are currently in some of the facilities for receiving care?
So yes. So in general, let me explain how we help bring up concerns by residents and those being addressed. So we have a sick call list where we have our nursing staff see residents and triage patients. So that's one. Once they go through that process, seeing physicians, seeing nurse practitioners, that is the next step. And so in general, we are doing okay when it comes to our sick calls. We are moving in the positive direction when it comes to being ahead of the curve and not having any wait time. But yes, overall, we are doing fairly well.
Yeah, I mean, some of the reports I'm hearing is weeks. What would you say is fairly well?
So it's a case-by-case scenario, depending on the individual's circumstance and what they are complaining of. For example, if we have somebody that's complaining of chest pain, well, that person will come immediately into our clinic, into our fold, and be seen. If somebody is, complaining of, let's say, I'm not sure, a hangnail or something of that nature, that might be triage and be a couple of weeks. But depending on the severity and the acuity, which our nursing staff uses their protocols, and also elevating to us, patients can be seen immediately. And this is a everyday battle in the sense that, this morning I was at Maine State Prison. We had one patient that had a skin infection and then be sent to the hospital. We had another individual who had a neurological event, but these were cared for appropriately because they were appropriately brought to our attention.
It's interesting you mentioned the skin infection going to the hospital. I'm wondering if we were seeing the same man. Were these like lesions on his back?
No.
No.
Yeah.
So if you had like skin lesions on your back, how long would it normally take? Where do you think, if it wasn't responding to treatment, how long do you think it would normally take before you were being seen for a follow-up visit?
Mm-hmm. So our nursing staff is triaging right there in the housing unit. They're there every day. And so they can be triaged right there. If it needs to be elevated to the medical clinic, that person can come that same day if it rises to that acuity level.
So if a resident said they're having a problem, the nurse would see them that day?
They have the ability to, yes. They're there in the housing unit, yes.
And then how long would they normally see till they would see a doctor?
So it completely depends. I mean, sometimes a nurse can just call the clinic and say, this person needs to be seen now. And that person can then be beeline to the clinic. And then we're seen by either me or our nurse practitioner, as it say at MSP. Yeah.
Okay, so the nurse practitioner or your staff would be on staff during 9 to 5, Monday, Friday kind of thing.
Correct, correct.
Great, thank you. Have you ever, or do you know of an experience nationally where a WellPath has resident advisory committees or does feedback surveys in terms of, like, you know, I am often asked, you know, for doing a patient survey after getting care from the doctor. Do you do that kind of thing on any level?
So nationally, I'm not sure, but I like your idea. I'm a firm believer in member advocacy committees. And I really actually like that idea. I really do.
Great, thank you. Okay, and then it sounds like you are involved at MSP somewhat on a regular basis, which yes. I represent Warren, and I live just a couple miles from MSP in Bolduc.
Yes.
Yeah, and so I know that there's been some issue over the last few months with KOP meds and getting access to those and some difficulties in deliveries and that kind of thing. Could you give us some details on that?
So when it comes to medications, you know, our residents have the ability to have what's called KOP, means keep on person, which means the medication is with that individual as opposed to going to a med line. Okay, so KOP is there. Recently, with what we had through the weather that happened, particularly in Texas and that area, the shipments a day or two did not come in on time. But beyond that, as far as KOP goes, our residents have access to KOP medications. Yeah.
So it would be unusual if somebody had to go a week or two without blood pressure medication.
Correct. No, those are reordered and brought, you know, it's out the card and the patient has access to the KOP. Yep.
So if somebody was experiencing that, and I suppose they would put in a grievance of some sort?
Yes, that's correct.
And what's the grievance process? Yeah.
So usually once the grievance happens, it is triaged by our health services administrator, so the medical administrator, and they review all grievances and then they respond to that. If they need further information from, let's say, myself or another provider, they will then do that. And then there are occasions where we bring a patient to the clinic to resolve the issue if they haven't been seen or something came up. Yep.
So that's handled by WellPath. DOC isn't directly involved in that procedure process.
So I may need some help here, but there might be more than one way to do a grievance.
Yeah, and I can just speak to that real quick, Dr. Ali and Representative Blucher. I can just add in there that the entire grievance process is overseen by the department, and so each facility has a grievance review officer, which reports to the chief administrative officer or the warden, and so that includes the medical grievance process, and it all falls under the oversight of the commissioner in our grievance review process, which really means that all grievances, if not satisfied, can be elevated up to the commissioner's level, and he reviews those on a regular basis as well. And that includes all medical grievances.
Thank you. I wasn't clear that the medical grievance process was the same as the general grievance process.
Hey, Bill, do you mind if I jump in on that?
Please
on the
do.
Grievance process for a sec? Just because I think it's a little different than when I used to represent WellPath, and there, you know, when there were complaints made against the licenses of the providers. That's a different process, correct? That's not the grievance process. So like there's a complaint made to the professional board.
Correct. That's a different process. And yeah, and Dr. John Newby would oversee that process in terms of a WellPath as the WellPath administrator for the state of Maine. But those challenges to licenses and complaints to boards happen outside of the DOC grievance process and the direct care processes.
Okay, so they don't need to go through grievance first before they can go that route, right?
No, they do not. In fact, some of those are actually made directly to those licensing boards.
Made right to the licensing board.
Mhm.
Do we get a report of grievances on one side and then professional licensing complaints on our committee?
No, so we at the department level, we track all grievances, and so we report out regularly. I believe the requirement is quarterly, and facilities report them out to us monthly on all grievance activities. But we do not overlay them next to board and licensure complaints and match those up. In fact, the board and licensure complaints are very few and far between to where they would even be reported to us regularly.
Do we get those on the committee?
I don't believe so. Dr. Ali, excuse me, let me go to Representative Lookner because I've already had the opportunity to ask a question. And if members could raise your hands, then we'll know if somebody else has a question, we'll make sure that we get to them. Representative Lookner, and then I'm going to go to Representative Rudnicki.
Thank you, Madam Chair, and thanks everybody for joining us today. I have, I guess, some kind of obtuse questions. I'm just sort of trying to get my head around, you know, the services that WellPath provides and the structure of WellPath. And is WellPath a 501c3 or a nonprofit, or is WellPath like, you know, a for-profit company?
Dr. Newby, do you want to handle that?
Sure. Thank you for the opportunity. Yes, no, WellPath is an LLC. We are a for-profit company. We are headquartered out of Nashville, Tennessee.
And thanks for that. And can you just, you know, this is, I'm just gonna, you know, how much are executives and the board of directors making? What's the salary, you know, for some of the top executives at WellPath?
Yeah, that's not something that I would be able to comment on specifically.
Is that
something? And I just want to step in if I could on a question around salaries and specific information, because I know there was a question around a specific salary. I just want to remind everybody we can't speak publicly about salaries, especially of chief medical officers and others while the RFP process is going on, because it would put the RFP process at risk. Things like salaries are part of the competitive bidding. It's part of what the scoring process is. So we just can't share that information publicly. And so I just want to make sure that we respect that RFP process that I mentioned earlier is
sure their way. Thanks, Dr. Thornell. Is there a way I can find in just kind of like the revenues in general, like how successful WellPath is as a company? Where can I find that information?
I'm sure there are means in which that information can be shared with the larger body of what our company does, but that's not something that I could disclose on this public hearing right now. I could probably get back with you if you'd like.
Yeah, I would appreciate that.
Next up, I have Representative Rudnicki.
Thank you, Madam Chair. I just want to make sure I'm hearing things correctly because, again, this committee is new to me, so I'm still in a long learning process here. But so the contract that we're talking about, that is the 26.8 million starting July 1st. And we are talking 1,700 inmates. Is that what this is? The amounts? Those are the numbers I heard. So I'm just trying to get a feel for here. Are those numbers correct?
Yes, that would be accurate, Representative. So we have approximately 1,700 adult men and women in our department, as well as the juveniles at Long Creek Youth Development Center, who also receive services under this contract.
And is this contract for a single year, the 26.8 million? Is that for a single year or is that a multi-year contract?
So the contract itself is a multi-year contract. The $26.8 million is this year's budgeted amount in that contract.
So we're spending $15,765 per inmate based on that contract?
Yeah, so that if that's what the math equals out to, yes.
Okay, thank you.
Next, I have Representative Searway, excuse me, Senator Searway, I apologize, and Representative Pluker.
Thank you, Madam Chair. Just a question to Dr. Alley. Just wondering, do you know what the percentage of administrative cost is compared to the medical cost for this project is roughly?
I don't know, to be transparent.
Yeah, and I would just, Senator Searway, if I could just, again, that's another piece of the scoring process and the competitive bid process is the administrative fees associated with the contract. And so disclosing that would, again, jeopardize the RFP process that we're currently in. And so if we could, there's a follow-up means that we could provide information for questions like that. And you know, Anna Black, our Director of Government Affairs, is really the conduit for that. So we can work with her to make sure that information or your question is resolved.
Thank you. Thank you. I just wanted to get a comparative cost analysis, that's all.
Certainly.
Thank you, Dr. Thornell. So your answer to Senator Searway was that Ms. Black will be keeping track of these questions and then giving this information on a private basis to the committee, knowing that this information cannot be shared publicly because of the RFP process. And so that we'll see that coming to committee members.
Yeah, so we'll do a follow-up to make sure we captured the questions and remaining topics, and then absolutely communicate back with you, Representative.
Thank you very much. And just a reminder that if Senator Searway asks it or Representative Pluker asks it, please view it as the entire committee has asked the question and we'd all like the answer. That's best for all of us to have the same information. And as you might imagine, that's very important as we make decisions together. Thank you for that. Let me see. Representative Pluker is next.
Dr. Thornell, you mentioned that salaries are part of the scoring process for the contract process. Is that salaries for all the staff, so line workers too?
Yes, that's correct. They're required to provide an entire staffing matrix and cost per position.
So would they score more if they were paying their employees, like their frontline employees, better?
The cost components of the RFP process, not just for this, but the RFP process in general, are based upon an algorithm. And so we don't make decisions based upon one number here or one number there. It's all based upon an algorithm from the Division of Procurement Services.
Oh, so just so I'm clear, so that if their frontline workers are paid better or worse, it does affect the algorithm, but it's hard to say how it would affect the algorithm.
That's correct. From a cost perspective, that is correct.
Okay, thank you. I had other questions about the contract process. Should I ask that later, or is now a good time to ask?
It seems like a decent time. I don't have any hands up from anyone else. So if that's agreeable to you, Dr. Thornell, I think we'll keep going.
Yeah, because the next transition will be over to the behavioral health side of things. And so we can address Representative Pluker's questions now.
Great. Thank you.
How many folks did you get responding to the RFP?
We had a total of 5 responses.
5 responses, okay. And I assume people are corporations that are doing business all over the country?
Yes, absolutely. They're all national corporations.
Okay. And then, you mentioned in this call a team of people who are reviewing the proposals. And I think in another conversation you and I had, you might have called it a stakeholder group. Are these the same groups that you're referring to?
Yes, it is.
I know you, in another conversation, went through who was in a stakeholder group. Could you just go through who's on that team and how that process happens?
Yeah, absolutely. And I'll list them by really their job title position, which is myself as the Deputy Commissioner. We also have an Associate Commissioner who's in charge of our support services, which includes finances, contract services, budgets, everything in between. We also have our Health Services Coordinator, who obviously is in charge of implementing that contract and overseeing that contract and the delivery of care. We have a contract expert who works with the procurement division to make sure the contractual process is followed, and who makes sure that the review process, scoring process, and all of those components are completed. And then the department brought in an external stakeholder as well, who is on an administrative role, oversight role at one of our large medical healthcare systems here in the state of Maine, to provide an external review of the contracts as well.
And is that group just the group that DOC, that I guess, how did you choose who was going to be on that group?
Yeah, so that group, the makeup of that group is chosen by not only the Department of Corrections, but also by the procurement rules for the state of Maine, but also in consultation with the governor's office regarding what the makeup of the committee they would like to see. And then I also should mention, we also have it reviewed and input from the Office of Information Technology and the Department of Administrative and Financial Services.
Thank you. I think that's the end of that line of questioning. Thank you for your patience.
Thank you.
I saw Representative Morales had a question.
Yes, I was wondering, I guess this is more for Dr. Ollie, thinking about, and I put it in the chat and just, I didn't want to forget it as Bill was talking, but how do we measure health success? And I know you're probably aware, but of the lower life expectancy for folks who are incarcerated. And I'm sure you measure that as a company. And so how does Maine compare with other states? And in terms of we have folks who are coming in with, well, I mean, we know most folks who are coming into our system, right? They lack the social determinants of health. They lack the community conditions necessary to thrive. So they're coming in not well, many. So what's the plan? Like, how do you manage that? And then how do you measure that at the end of the day? And then how do we know how well we're doing based on the work that you're doing?
It's a great question, Representative, and it's an evolving question. Not just for WellPath, but for the entire correctional system across our nation. I don't think we have firm quality metrics in the correctional setting for certain diseases, let's say diabetes, hypertension, hyperlipidemia. That is something actively WellPath is trying to move towards, the whole value-based care. And I know from WellPath's side, they are honing that as we speak. Me coming from the Medicare, Medicaid world, Medicare, Medicaid, they have certain cutoffs. Let's just say, if you're diabetic and you have a hemoglobin A1C, a certain number, those can be markers to help see how somebody is doing from their health. But I think that's part of why I'm here as well, to move us towards that quality base, to get a standardized way where we can measure outcomes and move the needle. And so how do we compare to other states? I don't know, to be very open.
What about life expectancy? Do we have that data in Maine?
So I'm not familiar with that data. It may be out there. I just do not know it.
Okay. Can I follow up with one question around Medicare and Medicaid, since Dr. Ollie knows a lot about it? Because one of the issues I find is that, when our folks are inside the prison, they don't qualify for Medicaid. And Medicaid services, when you look at Maine, if it's an average adult, it's about $7,000 a year. If it's an adult with disabilities, it's more closer to the $14,000 a year, which is kind of closer to the costs if going to Representative Rudnicki's math, which I did as well. And so how do we maximize that? And are there learnings or things that you've learned in the past before you came into this role that could help us think about this issue?
So Representative, let me make sure that I fully understand your question.
Yeah, it's a bad question.
No, no.
really bad
Is it more how do we provide a form of Medicaid for our residents? Is that the question? And for continuity of care? Or can you be a little more specific?
Yeah, that's good. The question is rambling, but it's, I don't think Medicaid, we can bill Medicaid, right? For inmates. Is that right, Dr. Thornell?
So there's one provision that does allow for Medicaid reimbursement for services that require hospitalization, 24-hour overnight hospitalization, 24 hours or more in a hospital setting. That is the only provision that allows for reimbursement from Medicaid while incarcerated, and then their benefits are activated the day of release into the community.
Right. Okay. That's my question.
Got it.
Thank you.
Dr. Ali, thank you so much for sharing the information about telehealth. That I didn't think about, and it makes me happy to know that that's happening. So folks have, even more access. Tell me what that looks like. I'm interested in residents having access to be able to testify. And I've been sort of running into some roadblocks around them having access to technology, but I'm hearing that they use technology to communicate with their families. They use technology to be in education programs, and they use technology somehow to receive health services. So I'm wondering where the climb is. That's not for you to answer, but what does it look like when you're providing telehealth to patients?
So in general, it's very simple. I mean, we have a laptop that's outfitted with a particular camera, and that resident comes to wherever that's located, whether it be in the housing unit or in the clinic. And we actually have an individual there that has attachments that we can listen to heart, lung sounds, carry a conversation with an individual who may be in a different state, or maybe me, but just not at that site. And so through that communication, as well as evaluation, we're able to see residents. So we're using that for not only medical, but for psychiatric, for MAT as well, hepatitis C, so things like that.
Thank you very much.
You're welcome.
Representative Pluker, did you have another question? I see your hand is up.
I did, just one more. How do residents and patients get access to their medical records? I know there has been some issue with folks sending out for tests that were done off site and then not knowing how to get access to those records after the fact.
There's a formal request that's made by the resident, and once they request, they have the ability to get their records.
Does the formal request go through WellPath or through DOC?
Well, actually, I don't know, but we have a form in our
Yeah.
EHR. Yeah.
Dr. Ali, if I could, it goes to the health services administrator at the site.
Thank you.
And is that something that could be approved or denied, or is that just a process?
Dr. Newby, do you want to speak to that a little bit about what the formal review process is for that?
Absolutely. Yeah, it's a formal request in which our resident patient would make an informal request to the health service administrator and request a copy of their records, and it'd be a simple matter of approved, and we'd make those necessary copies and provide those to them. And it's just that simple. We wouldn't deny a request for someone to have access to their health records. It's part of their healthcare.
Thank you.
Thank you, Dr. Ali, and thank Dr. Newby for answering all those questions. That's great. And Dr. Thornell, you suggested you wanted to move on. Everyone good now that we move on to behavioral health? Is that the plan? Okay.
Yes, Representative, thank you. Yeah, so I would like to turn to the behavioral health and SUD treatment topics, because I know there were several questions and there's a lot of interest in these topics. So I would like to introduce Dr. Robin Hodges. She's our Regional Behavioral Health Director. Dr. Hodges, in a much different way than Dr. Ali, has been with WellPath in Maine since the inception of the contract in 2012. And she has led the behavioral health clinical team through all of the various expansions that I mentioned since that time, which include the development and implementation of the IMHU, as well as working alongside me with MAT services and the like. So Dr. Hodges, if you would go ahead into your briefing on behavioral health services.
Absolutely. Thank you, Dr. Thornell. Good afternoon, Senator DeChambeau, Representative Warren, and the distinguished members of the Criminal Justice Committee and Public Safety. It is a pleasure to have an opportunity to speak with you today. As Ryan mentioned, or Dr. Thornell mentioned, I'm Robin Hodges. I'm the Behavioral Health Director for WellPath with the Maine DOC. I oversee all of the behavioral health services for Maine DOC, so that includes the full spectrum of mental health, SUD, which is our substance use disorder treatments, problem sexual behavior, the IMHU. I've been in corrections since 2003, so a lot of people ask, how did you get into corrections? It's always a popular question, and just sort of kind of fell into it when I was in grad school. We had to elect a emphasis, and forensics sounded interesting, and so here I am many, many years later as a psychologist working in corrections. So my experience has been primarily in jails, prisons, and state hospitals. And as Dr. Thornell mentioned, I've been with this contract since the inception for WellPath, which was in July of 2012. So I wasn't born in Maine, but I got here as quickly as I could. So I want to take a moment just to review some of our behavioral health services. So our behavioral health services starts right at the intake process, from our initial intake through all of our service provisions at all the facilities, and then transition to the community. And our goal is to provide the best range of services for our residents inside of our facilities. And over the years, we've really worked hard to increase our coordination between medical, mental health, and security to appropriately address any of those high needs and better address sort of the full range of treatment needs, which Dr. Thornell kind of hit on as we've developed different programs and enhanced different expansions. So our initial intakes, I'm going to kind of jump between juvenile and adult, so we cover both. Our initial evaluations on the adult side are completed within 14 days. So those are completed by master's level clinicians. On the juvenile side, a little bit different. Their initial intake when they're detained is also done by a master's level clinician. However, if they are committed, they're actually they have a psychological evaluation completed, which involves a risk assessment and other psychological testing that the psychologist would deem appropriate at that time to determine sort of service needs within the facility. We also have a comprehensive suicide prevention plan, and this is something that we've really sort of grown over time. We've definitely included a lot of, WellPath has a Zero Suicide Initiative Committee. We've wrapped in collaborative safety plans. And so our goal is to not have any suicides, obviously. I think that's everyone's goal. For Maine specifically, we have had 0 suicides since 2017. And since the inception of the contract, we've only had 2. How that kind of compares to the rest of the nation, in the Bureau of Justice statistics that were published in February of 2020, the national suicide rates for state prisoners was 16 per 100,000. So we compare fairly well with the 0 suicides in our state, which is fantastic. I think part of that is also attributed to our partnership with McLean Hospital. So McLean Hospital is here, but also in Massachusetts, very famous psychiatric hospital. I'm sure most of you are aware of them. We partnered with them on the Deconstructing Stigma campaign. And so initially this was just going to be for residents, but we also recognized the importance of suicide prevention amongst our staff. So we were able to bring several of their initiatives to the Department of Corrections for both residents and staff, which we found some benefits from. I would be remiss if I did not mention self-injurious behavior, because I think that's a popular topic in corrections. And so I'm proud to report that since WellPath has had the contract, we've reduced self-injurious behavior by 55%. So that's since 2012. And I attribute that to the collaborative approach in which we come at self-injurious behavior, both from behavioral health, medical, but also with security partnership. Some of the ways that the residents can access care for behavioral health is through our sick call process. So every pod in our system has sick call paperwork where individuals can fill out a sick call and put it in the box, which the nurse picks up daily and triages. Those come to behavioral health. They can also be referred by other staff. And they can also put in requests via the electronic tablet, which is our Adovo system, which has been a great way for us to have communication with our residents very quickly. And that was one of our initiatives through COVID, was to find a way to communicate with the residents more effectively when we couldn't communicate with them in person. We also offer group and individual treatment. And so our treatment is gender responsive and evidence-based. So we offer a variety of different treatment options for people just based on their individual treatment needs. So I'm just going to talk about a few. We have many, but I just want to hit some of the higher point ones. So we offer CBISO, which is a curriculum for problem sexual behavior. We also offer CBI IPV, which is a curriculum for interpersonal violence. So individuals who are in our systems for interpersonal violence, we also treat them prior to return to the community. We also offer grief and loss, meditation, co-occurring disorders. We also offer problem sexual behavior treatment for the juveniles as well, which has been a program that was developed within DOC actually prior to WellPath coming on board, which we still use. And we also offer fire setting treatment, which is an ACART model out of Australia. There's not a lot of models out there, but we use the ACART one. And then we also offer family work, in particular with the juveniles is where we focus our family work. But we also do family work in the IMHU. And so that's a place where we've been able to maximize Skype visits prior to COVID, of course, to sort of reintroduce individuals back to their families, get those connections going and those supports going where they were lacking in the individual's life. We also have a program called Special Needs Monitoring, which is individuals who are higher on our radar for psychiatric conditions, or they may have been on a suicide watch, which was concerning, or they have concerning behaviors within the facilities. And so those are individuals that we see monthly just to sort of check in on. They have treatment plans, sort of see how they're doing and check in to see if they need anything or if we need to make any adjustments with their care. We also have a behavioral health tech program, which is in several of our facilities. And our behavioral health techs are bachelor's level individuals who essentially take the treatment that the master's level clinicians are doing, or the psychologists, and roll them into skills. So part of learning skills is practicing skills, right? So we got to make sure that everything that we're sort of trying to get the individuals to learn is actually practice. So the behavioral health techs really sort of take that information and put it into practice in the facilities. And then we also have obviously rounds for restrictive housing and in our quarantine units. Obviously during COVID, we had quite a few rounds going on when we were experiencing some issues there. Let's take a moment and transition to psychiatric services. So for psychiatric services, I know there was a question about number of individuals who are on psych meds. So an average over the past year is we've had about 733 males on psychiatric medications. For females, 108, and juveniles, 28. So that's the average over the past year. Some of the other services that we offer in behavioral health, in addition to psychiatric meds, groups,
Can
are...
I stop you there?
Absolutely.
Can I stop you there? A little, I missed, you said 730 men?
733 men, yep.
And then
That's the
how many-
average over a 12-month period.
Right. And how many women?
108.
108. And then 28 children?
Correct.
And what does that mean? Like, what are they, what is the universe of medication they're on and why?
So it really ranges. So if they are on psychiatric medication, it can be for a diagnosis of anxiety or depression, ranging all the way up to bipolar or schizophrenia. And so it's kind of every diagnosis in between as well. But if you are on psych medications, you have some form of a mental health issue that we're attempting to address both with psychiatric medications and if they're open to treatment. But our gamut of mental health diagnoses and corrections is fairly interesting because you see a lot of diagnoses that you wouldn't necessarily see in the community, like delusional disorder or conversion disorder, which we're also treating in our system.
And do you track that over the years to see, is that increasing, kind of going to that quality measurement and performance measurement? Like, how do we, I know you track things like suicide. You probably have to. I don't know if you have to by federal law, but what are we seeing? Trends, health-wise, what are we seeing in folks? What do they need?
So yes, we do track trends of psychiatric medication over the years, of average number of individuals who are on psych meds. And so we do track that. We track suicide rates, suicide attempts. We look for particular trends to find out, are there particular times in the year that we see individuals who are requesting more medications or, engaging in more suicide attempts or what we used to call gestures, which we don't call them anymore, but more threats or self-injurious behavior. So we definitely, as we collect data, we review the data to see if there are trends that we need to be paying attention to and focusing on. And so probably our best example is that we saw when we first came to Maine was that the self-injurious behavior was significant. And so that was an area based on the trends that we had seen coming into this contract that we really wanted to address. And so over time, we were able to reduce that by over 50%. But we wouldn't have known all of that information if we hadn't been getting data about it.
Right. Yeah, it'd be interesting just to learn more about those pieces of how can we, what are we learning about what folks need? Are we addressing suicide ideation with psychotropic medication? I know there was one of the questions there was like, how much are we spending on that? I'm not asking that because I don't think people need it, but like just wanting to get a sense of, how can we best help folks? Ideally, I want folks not to be in prison. So I think, if they can be successful in the community and we can get them back with their families and connected with jobs and opportunity. And I think we're all in agreement on that, as long as public safety is an issue. I think we all probably want that.
100%. I think we all have the same goal in mind of, I don't want to see people in prison either, but they are in our custody. And so the best thing we can do is make them as empowered and successful as they can to return to the community and not recidivate, which is, I think, everyone's goal on this call is to, ensure we have individuals who are, connected with services and getting those services, because we don't want the department to be the place where the services are accessible. And we need to make sure we have a good continuum of care for sure.
Thank you.
You're welcome.
Dr. Hodges, I have a couple of questions, and I know you're going to move on to other pieces, so I want to make sure that I ask them. And then I really have a lot of questions, as I know you've received, and a bunch of us had a lot of questions about MAT. And so I want to make sure that we're able to really focus on that. I think that's part of what began this conversation. Thank you. The first question I have is, I just want to make sure I have these numbers right. You're reporting to us that average over a 12-month period, the number of residents receiving psychotropic medications are 733, 108, and 28.
Correct.
So 51% of the folks incarcerated in the Department of Corrections are taking psychotropic medications.
Correct.
Thank you for that. I didn't want to mishear that data, and I appreciate that. Before you move on to the next section, I want to circle back to the tablets. So what you said to us was that because of COVID, and I understand, here we all are, right? I'm in my office at home, which I never would think that I would be doing this way, but here we are. And so part of the way that you've been able to provide care to folks who are residents of DOC is to make sure that they all have access to tablets in a way that they can then communicate with you or with your staff, excuse me, if they need support.
Correct. So prior to COVID, the DOC had launched what we call our Adovo tablet program. And it was a way for residents to engage in different programs that are available, education services. There's a whole host of things for them to engage in via Adovo. So when COVID hit, like most individuals in the world, we were scrambling to figure out how we can increase our communication with the residents, especially when they're in quarantine or in areas that we couldn't really, which was not a great area for us to have face-to-face access at that point. And so we reached out to Adovo, who was very kind to allow us to pilot a way for us to communicate with the residents. So those tablets also have ability to send and receive text messages. I don't know all the logistics of it, and Dr. Thornell can probably cover that a little bit better than I do, but they have some capabilities. And so based on that information, we spoke with Adovo to open that capability up. And so the residents are able, I was just actually answering Adovo requests this morning related to MAT and SUD and mental health. And so they're able to send it just straight from their cells, and we get it on our portal and we respond back. And so sometimes it's, I'd like to see someone, and we can give them that really quick response of, we'll put you on the schedule and we'll have someone come see you very soon, or I'd like to be on the MAT list. But it's a great way to really quickly communicate versus the paper sick call system. I do want to be clear, though, that not everyone has the access to Adovo. There are some limitations to where we were able to deploy that. So not everyone has Adovo. So individuals who don't have the Adovo still have access to us via sick call slips.
And would you say that you're also providing, so that made a lot of sense to me. Thank you for that. People can request assistance, help. Are you also providing, in the same way that Dr. Ali talked about providing services through telehealth, are you able to provide these services through telehealth to the folks who have the tablets?
Not via the tablets. So our telehealth is very similar to Dr. Ali's, in which a laptop is set up and we're able to meet with individuals in an office or a remote clinic. Also through COVID, we also started using what we like to call Zoom phones. And that is a regular cell phone that has been adapted for Zoom capability. And so officers will take that phone and give that to the client, which has been interesting because not all of our areas have really good cell reception, but we've been working with that and finding our spots where we can get cell reception. And then a clinician is able to meet with the resident via the Zoom phone.
That's wonderful. Thank you. And one more question about this. Has it been a problem if, let's say, somebody needs care, and so they're going to be given one of these Zoom phones to communicate? Are there backlogs because there's not availability of staff, or are there staff? Because that's one of the things that Commissioner Liberty and I are discussing. You know, I've been on this committee, this is my 7th year, and I've always wanted to hear from the folks that every piece of work that we do in this committee affects. I've always wanted to hear from them. So I really saw COVID as finally an opportunity to where things, you know, like things are tough for everybody, but this is finally a bright light where maybe we could actually hear from the folks who are really affected by all of the work that we do. And so I think Commissioner Liberty and I are going to be having, you know, continued conversations. What I heard was that there were a lot of technological issues, but what I'm hearing from educators and from healthcare providers is that those aren't existing. So both can't be true at the same time. I'm going to be interested, Commissioner, in having conversations as we go forward about that. So you're saying that folks aren't not able to get their care because there isn't enough staff to provide them with a Zoom phone.
Correct. People are getting their care. And if there's not enough staff to take a Zoom phone, then we will go into those areas and see people cell side. But we found that the Zoom phones are a way for us to interact more with individuals who are in particular quarantine areas.
Got it. Thank you so much.
You're welcome.
That's what I had. Thank you. Representative Pluker.
Thank you. I know that we've been having a problem with a lot of those eDovo tablets breaking inside, and I was going to ask you the question of what do you do if people don't have access to those tablets? And I think you might have answered that question. They just put in a sick call note. And is there a similar question that I had earlier? What kind of wait list is there for seeing folks who put in a sick call note?
So individuals who put in a sick call are seen within, usually where our goal is 3 days. We have a week to see them, but we see them rather quickly. So we don't have any, for behavioral health, we don't have any wait lists for our sick calls. We respond to them fairly quickly.
Great. So if somebody was, if someone was in the general population and their mental health situation was rapidly decompensating, how would you be able to deal with that?
So that just happened last week. And it happens on a regular basis. Essentially, we're reliant. I mean, behavioral health can't be in all places at all times. And so we're really reliant on our security partners, our healthcare staff to be the eyes on the ground for us when we're not with individuals. And so they're the ones who will contact us. We have a on-call system and we're available. We carry radios in the facility. So they contact us and say, this individual is not doing so well. Can you send someone down to see them? And we will see them that day. Or if it's after hours, one of our healthcare staff will see them and then contact mental health on call and we'll direct how that's handled.
Thank you. I'm going to get this phone that's ringing and then I might have more questions. Thank you so much.
Thank you, Dr. Hodges. I have no more people with their hands up.
All right.
Representative Warren, could I just jump in real quick? And I want to make sure that we make the most use of your time, the committee's time, because we still have quite a bit of information to brief you all on. And I know you mentioned you specifically are interested in a discussion on medication-assisted treatment. So I just wanted to check in with you in terms of what the time looks like this afternoon. We're at 3:20, because I want to make sure Dr. Hodges can focus her time and any remaining time on where you really want it for your committee.
Thank you. If committee members disagree, please weigh in on this. I think we are getting through some of the questions by having the ability of being able to have a fluid conversation. We have not really had a chance to get into MAT. So if we could move to that now, Dr. Hodges, that's where a lot of our questions originate. And let me let my co-chair, she may disagree with me. So let me make sure we hear from Senator DeChambeau.
I don't disagree. I'm just on the other side a little bit. Hello. I finally went to Spectrum and told them to check my connections, and now they haven't kicked me out. So that's why I'm here. I apologize if what I'm going to ask you, you've already touched on. And by the way, hi, Robin.
Hi, Sue. Good to see you.
You were there when I was there. So
yes.
And before we go to the MAT program, something very dear to me, obviously, is case management. Who is this, not who, but what's the title of someone that, do you still have caseworkers there? Okay.
Absolutely.
Do they work side by side with state caseworkers also?
So let me just sort of clarify. In October of 2020, WellPath, we did have the caseworkers, as you recall. And in October of 2020, we shifted those caseworkers over to the DOC side. So all caseworkers now are employed by the DOC and no longer with WellPath.
That's good and that's bad, I think. because that answers my next question. That's not even a question. I recall, and I will tell the members here, WellPath did a terrific job in ongoing training with their caseworkers. The only problem is the state caseworkers didn't have the same training, nor did they participate with the WellPath. But maybe this will change and be a little better. I won't add any more, but I want to tell the members what I've heard in the last hour. I've been doing a lot of nodding. I want people to realize that, and especially Robin's background, and she's right in the thick of things. You address issues, you see the big picture and the little picture. So I give a lot of respect to you and your staff on that. So thank you. But my nodding, and for those of you, and forgive me, Representative Warren, if I'm going to make just one statement for those other people, Mr. Newby, Ali, and some others. The reason Robin and I know each other is I left the Maine Correctional Center 5 years ago, having served 43 years. And Mr. Tornell, we were the old school. Yes, I see you improved it since I left. Okay, so thank you. But having had that wealth of knowledge, everything that I've heard, you guys are right on point. You have a handle on the situation, so thank you. So you can take it on the other one. Thank you.
So Representative Warren, if you want, if we're ready, we can shift over to MAT.
That would be wonderful.
And if I could, I would just jump in real quick and provide just some background information on the budget and numbers questions that were asked, and then turn it back over to Dr. Hodges for the clinical side of services. And so just real quickly, we kicked off MAT, as you all know, in 2019. That first fiscal year, we had budgeted roughly $1.2 million for medication-assisted treatment services, and that was funded in part by Maine DOC general funds through the WellPath contract, approximately $800,000 of that. And then the remaining $400,000 or so was from what is now the Office of Behavioral Health under Department of Health and Human Services, formerly the SAMS agency. I'm pleased to report that fiscal year, we only spent under $500,000 of that initially budgeted $1.2 million because the rollout was much more efficient than we expected. And the same trend has continued into the current fiscal year. Because we had planned expansion, we had increased our proposed budget to $1.7 million. Again, braided funding from the same two agencies. And currently, even with our expansion that we've planned and spoken about with you all previously, we're on target to be well under budget to the tune of probably spending around $900,000 during this fiscal year. And a majority of those costs for the services go for medications, number one, but also medication-assisted treatment nursing services, specifically for those program services, and then continuity of care service coordination for release purposes, and counseling services that accompany that pre-release process and discharge planning process. And I want to mention the cost savings are really due to two things. Efficiencies in staffing. DEA X waiver changes along the way have made it so prescribing practices are much more open and much more efficient than we had originally anticipated, which saves significant money on the staffing side of the services. And then also, as we've spoken about, our normalization processes for medication administration, where we are administering the medication in a much more normal fashion, requires much less security staff in the distribution of medications, is going very well. And so that's another staffing and cost efficiency. And then real quickly, to date, we have provided MAT services to a total of 554 men and women, and that was as of the end of January. And so the breakdown of that is 464 men and 90 women have received services. And currently we have on any given day, roughly 225 men and women active in MAT services in our facilities. And that number is increasing daily as our expansion is now underway. And so we are adding more and more men and women to that number every single day. And Representative Warren, I do want to note, because I know there are questions about the medications that are used, and Dr. Hodges will be speaking to that because I know it is a topic of interest as well. So Dr. Hodges, if I could turn it over to you to go into the clinical components.
Absolutely. And actually, I'll start with the medications we use since that's an interest to all. So the current medications we use in our program are Subutex, Suboxone, Methadone, Naltrexone, and Vivitrol. I'm going to give you guys some numbers. So here comes some numbers on people who are also on these medications. So since July of 2019, we've had 351 residents on Subutex. We've had 548 individuals on Suboxone, 4 on Methadone, 32 on oral Naltrexone, with 11 of those residents switching over to the IM version, which is Vivitrol. We can also offer Sublocade, though none of our residents have opted to take that medication at this point. I think it's also important to note, and Dr. Thornell may have covered this in a different meeting, but we did start using, when we first started our pilot, we were using Suboxone. And then in October of 2020, we switched over to Subutex. So that's where there's kind of a change in the numbers. So when residents are on MAT or they express an interest in receiving MAT, we connect them. I'm going to sort of go into kind of the release process. So they're on MAT. And so I'm going to talk about the release process. Then I'm going to come back and talk a little bit about more SUD services in general, because it's all under one umbrella for us. So when they're 6 months from release, for those individuals who are on MAT or who have expressed a preference to start MAT in the community, we refer them to our partners who are Groups Recover Together, and also Day One, depending on what facility they're at, depends on who they're referred to. And part of their partnership with us is that they will engage the residents at that 6-month window and begin to develop a transition plan in conjunction with the case manager. They also offer weekly groups that are available to the residents if they so choose to attend. Obviously, COVID, that looked a little bit different. So we were doing what we call distance learning, where we would send packets for people to review and then send back to the facilitator. Both agencies offer a smooth transition to the community, as smooth as we can make it. Our goal overall is that a community appointment for MAT is set up within 3 to 7 days post-release. So that's our overall goal. And we try to hit that as frequently as possible. We don't like to have a gap in services coming out the door. So we try to get them into services as quickly as possible. In addition to those services, we also have a peer recovery services. And so we're partnered with an agency that will coordinate a meeting prior to their release with a recovery coach, who then would be their recovery coach in the community. And these services, everything I just sort of talked about for MAT-wise, is available to both residential and outpatient. So there's no distinguishing, if you're residential, you only get X, or outpatient, you only get Y. It's available to all residents in the DOC. We also have weekly discharge planning calls for our individuals who are releasing on MAT. And this is important because we want to ensure that every release is smooth. They have a place to go. They have their community appointments. They have access to telecommunication, because a lot of the community providers are doing tele. So we ensure that they are either getting access to a phone, or we're providing a phone for them to be able to access their caregivers for group meetings and also provider appointments. If an individual opts out kind of midstream of MAT, let's say they start MAT and they decide this really isn't for me and I don't want to do this anymore, all the services that I'm going to talk about in a few minutes around SUD services, they have access to all of those. SUD services, mental health services. MAT is a choice, so they can choose to opt in or opt out of that program. If they choose midstream, where they are engaged in their medication and they feel like it's not a good fit or they're having side effects, they work with the providers to taper off that medication. But services are still available to them. I think it's also important to note that every resident who is releasing on MAT is given a naloxone kit, which they're also given education about how to use that prior to their release. And so in that kit is 2 doses that they get when they are walking out our door, along with their release medications. I just wanted to stop there because that's kind of the overview of MAT services. I'm going to jump into SUD services if everyone's all right with that.
Dr. Hodges, could I just clarify one thing in case it wasn't clear? When the mention of a follow-up appointment in the community between 3 and 7 days, I want to just clarify that there is a prescription provided to them upon release for that same period of time, just like any other medication. So they're not going that period of time without medication. We align the medication period with when their next provider appointment is. So there's no gap in medication services.
Good point. Thank you, Dr. Thornell.
And Dr. Hodges, thank you for that information. When the determination is made, so tell me a little more about how the determination is made for who receives what medication. I think
Absolutely.
Yeah, okay, thank you.
Yeah, let me tell you a little bit about the process and then that will answer the question. So if an individual is interested in MAT services, they send a sick call slip or some sort of request. Behavioral health will then see them. And once they're inside the window for being prescribed, or a little before the window. So right now we've had our expansion to 1 year. So individuals are seen by a behavioral health clinician and a complete SUD assessment is done for them at that point if it hasn't already been done for SUD services prior to that. Once that SUD assessment is done, the behavioral health clinician refers them over to a provider. So regardless of the established diagnoses that behavioral health has for them, they still see a provider for final determination of MAT, and to have that interface with the provider to discuss if there's any other options for them or what medication they would like to take. So within the Department of Corrections, our primary medication is Subutex. And then we also offer the Vivitrol. We've more recently been having individuals come in on methadone. So we've been continuing the care on individuals who are on methadone. And then we also offer the Vivitrol and Sublocade.
Thank you very much.
No problem. Let's talk a little bit about SUD services. So in the department, we offer a variety of different SUD services that includes evidence-based and gender-responsive treatments. So we tailor our treatments towards our juvenile population, our female population, and our male population. And we utilize the risk needs responsivity model to kind of determine treatment need and level. When an individual first comes to to the Department of Corrections, we do a mental health intake, and part of that intake is a screening process for SUD services. So they fill out a screener with the clinician, and the clinician makes a recommendation at that point for further assessment. Then we do a full assessment, and from that point, kind of determine what their treatment need is, whether it's outpatient or residential. And this covers the full range of SUD diagnoses. So OUD, I know, is a very popular one, but we also have individuals who are in for alcohol abuse and many other SUD diagnoses that we capture through our SUD program. Just to sort of put a little context to it, last year we did 691 SUD assessments for individuals who were either interested in SUD services or particularly MAT. Either one, but 691 assessments were completed. So we have a variety of treatments. So our 2 primary treatment options are residential and outpatient for the male population. Juveniles is obviously all outpatient, and females looks a little bit different because we don't have a residential for them, but we've altered our services to offer a more intensive level of treatment to them for individuals who would have qualified for residential versus just our general outpatient. So some of our curriculums that we offer are we sort of make the gamuts of options. So we have groups that are targeting individuals who are pre-contemplative, who really aren't sure they want to change. So we have curriculums, one in particular we use is Stages of Change. We use Living in Balance, which allows us to sort of construct through their modules a series of groups that can be targeted just for SUD, or we can make that a co-occurring group, which has been great. We also have programs like Helping Men Recover, Helping Women Recover. We also offer a more intensive treatment, which is called CBISA, which is out of University of Cincinnati, and is focused on cognitive behavioral skills. And it's about a 6-month-long program. And then obviously we have relapse prevention. We do individual sessions are available to the residents, and then interactive journaling, which is also a way that we've enhanced services during COVID in particular when we were able to see them face to face. But the interactive journaling is a great way to reach people, and in particular people who aren't interested in really sort of engaging in a group. So we offer those variety of services. As some of you may be aware, historically in the DOC, we've treated individuals at the end of their sentences for SUD. And that is something that we have been working on changing. And that's with the exception of Long Creek. For the males and female adults, it's historically been at the end. However, we've been successfully able to change our model with the females. It's a much smaller population, and so we were able to move the SUD assessment much closer to their admission. And so we are working on keeping their services as close to the front end as possible. And we've been diligently working on the male side to move those SUD assessments to the front end as well. A little bit about our wait list to give some context. So our wait list is sort of demonstrating those efforts to get those services on the front end. So at MCC Women, so at our Women's Center, we have 16 individuals on the wait list. SMRC, which is our women's pre-release, we have 2. At Mountain View Correctional, we have 27 on the wait list. MSP, we have 90. MCC males, we have 137, keeping in mind that that's the intake facility. So as soon as we get people off the wait list, more people are being added on a daily basis. So that number will always be a little higher than all the other facilities. And then we have 115 on our wait list for residential. So our efforts have been really enhanced to sort of move those services to the front end. We've been involved in the Yale Project, which is a research change project focused on expanding, front loading, and bundling our substance use disorder treatments to include OUD, Hep C, and we're using the NIATEX change model to drive those changes. We're also in the process, as we sort of mentioned, we talked a little bit about EDOVO, but we've been really sort of trying to explore more use of those tablets to enhance SUD services as our starting point, and then we'll continue to grow that for other areas. But with the addition of MAT in general for the department, we've seen much more participation in SUD services and many more requests to actually participate, which has been fantastic. And just to note, WellPath is a licensed SUD agency in the state of Maine, so we're compliant with all the regulations governing the delivery of SUD treatment in the state. In addition to treatment, sort of moving kind of to where the clinicians don't do the work, but there's a peer recovery program that we offer. And that's peer recovery coaches, where individuals are trained to be coaches in the system and they coach up other residents. We also offer AA and NA. And then once they've sort of completed their kind of core SUD treatment, they develop their relapse prevention plan, which they have a copy of, they can share with their family and friends, with their case manager. And at that point, when it gets closer to release, we talked a little bit earlier about where groups in day one come in, but case management is involved the entire way. But that's where we sort of pull together and figure out where we're going to find housing for them and make all the appropriate referrals, not just for their MAT appointment, but for AANA for their areas, housing and other services that might be beneficial for them to make them successful post-release. So a little bit about kind of where we're at with treatment is that in 2019, we had 607 individuals complete SUD treatment. And in 2020, we had 449 individuals complete SUD treatment. And like most individuals, just like in the community, the resident has to really want treatment for treatment to work and for them to be engaged in treatment and for it to be a positive experience for them. And so just in closing, I really look forward to continuing my work in the Maine Department of Corrections with WellPath and to expand what we've already accomplished in order to provide the best care for individuals living in the state of Maine. And I appreciate the opportunity to review our work and achievements with you guys today.
Thank you, Dr. Hodges. That was very informative. I have first up Representative Lookner, then Representative Pickett, Representative Pluker, and Senator DeChambeau.
Thank you, Madam Chair, and thank you, Dr. Hodges. That was a great explanation. I'm trying to understand kind of what does, so you have 28-day inpatient substance abuse disorder treatment available within DOC, within WellPath. Is that like a 28-day program?
No, it looks very different than the community. So our residential program is 6 to 9 months. Sometimes it can be 12, depending on if they're not really engaging in the beginning. But our programs for residential are several months. The 28 days is more of your kind of detox programs, which in the community, but ours are much more lengthy. Our outpatient programs range from, one particular group could be 12 weeks to 6 months.
Interesting. So, somebody has a year sentence, they could potentially spend all that time within doing SUD treatment, like a residential program within DOC.
So if they come in with a 1-year sentence, we're going to be looking at a variety of risk factors. So individuals who may have a high needs SUD may also have high needs in other areas. And so we'll try to develop a treatment plan that makes sense for them, for their stay. So everyone's sort of looked at individually. If they come in with a longer sentence of, 4 years, that's easier to sort of get them into residential. But once they get to that 1 year or less, really residential is not a great option, because our goals of residential is to get them the treatment and then try to get them to a minimum so that they can begin working in the community and make a smoother transition.
Interesting. I just have I have clarifying questions. So how does residential treatment, what is that? How does that differ? Because you've got residents, like, somebody comes in, presumably most residents have substance abuse history, or I'm sure like a good portion of them do. So how does like a resident who's not in treatment versus a resident in treatment, what does a resident in treatment's day look like, and how drastically does that differ from somebody who's not in treatment?
So if they are in a residential program, so we have a residential program at Maine State Prison and Mountain View Correctional Facility. And so their day looks a bit different, obviously, than general population. So the residentials are much more structured, where there's a schedule for the day, where they, just sort of randomly kind of mix both. There's a community meeting, there's group engagement, there's individual work, there's homework, there's time for rec, there's time for peer support. And so their day is very structured in the residential versus general population, where someone may be engaged in an outpatient group that meets 2 to 3 times a week. In residential, it's happening every day.
Interesting. And just so for juveniles, it's only outpatient, so they're only getting grouped like 3 days a week.
Juvenile looks entirely different. So the juveniles are given a larger dose of treatment depending on their need, because the juveniles start their treatment immediately when they get committed, and their treatment needs are set up for their individual needs. So maybe they need 3 times a week group and 2 individual a week. And they sort of, like, our day one partners construct their particular SUD plan in conjunction with the mental health work that they're doing as well.
Great. And just, I guess my last question is around acute detox, sort of. So, I mean, I guess that's for like residents who are coming right in. Do they, or even residents who are becoming addicted or dependent within. Do you find that happening a lot? And what does like detox look like within DOC?
Sure. So we don't see it as much. The jails certainly see it on a very regular basis. We don't see it as much in DOC, but we do have protocols and procedures in place for an individual who comes in who's reporting that they are detoxing, or if somewhere in their stay that they're reporting it. We have all of our we have nursing pathways and a whole procedure within WellPath that we manage our detox with.
Okay. Thanks for that explanation.
Absolutely.
Representative Pickett.
Yes, thank you, Madam Chair. Not a question, just a comment. Thank you very much, Mrs. Hodges, I believe it is. Thank you very much for the presentation. It's been a lot of real good, useful information here and stuff, very complete and thorough, and I commend you for it.
Thank you. I appreciate that.
Senator DeChambeau, Representative Pluker, did you put your hand down? I had you on my list, but you're. Okay, Representative Pluker, I had you on the list, and then Senator DeChambeau.
Oh, sorry. Okay. That phone call that I got was a guy from SEG. He's been trying to get in. He says he has autism and he's had some suicide attempts. He's trying to get into the IMHU. Could you give me some details on how that review process happens?
Absolutely. So individuals who are in our restrictive housing units or anywhere in general population are reviewed by our behavioral health clinicians to determine if they are needing a higher level of care, which is our IMHU for our males. And at that point, the mental health directors become involved, and those are the psychologists at the facility, and determine if that is an actual referral they'd like to make, if there's an absolute need for a referral to a higher level of care, and then that is actually kicked over to me to review. And then I review that with Dr. Thornell, and we make that decision whether they're placed in the IMHU or not at that point.
And what would you be looking for in terms of needing a higher level of care than they're receiving in restricted housing?
So it runs the gamut, to be perfectly honest. So we're looking for individuals who have a major mental illness that are struggling to manage in general population, as evidenced by either some sort of decompensation, or they have an intellectual disability and they're not able to function appropriately. I will say that individuals in restrictive housing, we see them regularly. So if there is anyone in restrictive housing who is in need of IMHU placement at this point, they would have already been moved.
Thank you very much.
You're welcome.
Senator DeChambeau.
Thank you. Robin, for the past hour that I've been on, I've heard a lot of good stuff about mental health and any kind of treatment program. But I keep thinking about the role of the CO. This is not a medical facility, it's a correctional facility. And a number of line staff are correctional officers who are trained a little differently. I just would like you to comment, or maybe Dr. Thornell, how these programs get, how we educate correctional officers and how they respond. And if you've seen in your 8 years there, 9 years, a change in attitude or acceptance or non-acceptance. It's a different culture. So I guess I'm asking for the connection of line staff, correctional officers, and your programs. And be
Absolutely.
Honest. Be honest.
I will. I'll have to be honest with the person I used to steal their office. So, though your office looks much better now. So, it's a really good question. And I think back to the time that we worked together at MDOC, and I've seen a significant culture change. And so what we've seen over time is an inclusion of our officers in decision-making. We've been rolling out education programs. And so to give you just a couple of examples of how things have kind of shifted, before we started MAT, we put a survey out just to sort of see where our staff were. Like, what are their thoughts on MAT? We got that information back, and then we involved some of our officers, behavioral health staff, and administrators to create a training that was then delivered to our entire department, from officers to librarians, you name it. They got training and information on MAT. And then we did another survey to find out sort of how people adjusted to that information. And we continue to sort of include our staff, in particular our officers, in those decisions. When we were going to normalization, they're right next to us making those determinations. And so I think that the culture shift under Commissioner Liberty and under Dr. Thornell is tremendous, because we've really included the officers more so than I'd seen in the past. And so even when it comes to the IMHU, individuals who are new staff to the IMHU receive a 40-hour training on the IMHU to ensure that they understand exactly what it is, and if they're assigned in that unit for coverage, that they really have a good understanding of the treatment we provide and why we provide it and how that actually looks. So I would say that the culture has shifted dramatically, and I feel like our officers are included in those decisions, where before perhaps it was more of a directive versus an inclusion in the conversation to have a seat at the table with us in making those decisions.
Thank you. It has nothing to do with the fact that I laugh, that's for sure, anybody. But no, I've often felt that officers were underutilized, and they're part of the community in their own towns. And they even have children that suffer from all these problems. I'm glad that WellPath has reached out, and that the commissioner's office has reached out. We used to say, and you've heard it, anybody who's been in the business a long time, we are not a mental health facility, we're a prison, bang. And I don't hear that anymore. I still have contact with officers and supervisors, and the discussion is different. So thank you for, there are many members here, or a number of them, that have not had that experience or that know-how. So I'm trying to dispel the big bad wolf. So thank you very much.
Absolutely. Dr. Hodges, I think we are almost at least at the end of my questions, but I have a couple more for you, and I appreciate it. Specifically, I just wanted to hear a little more around alcohol use disorder. We know we have a real issue in Maine with alcohol use disorder. We spend a lot of time talking about opioid use disorder, but we have real issues with alcohol use disorder, and certainly it affects our cycling in of county jails, et cetera. But I know I'm asking somebody from the DOC this question. Can you tell me a little bit about what medications you use for alcohol use disorder in treatment, and what kind of services are provided to those folks?
Absolutely. Thank you for the question, because you're absolutely correct. A lot of the conversations center around OUD, and we have a significant problem with alcohol in our community. And so the primary treatments we use are the ones we discussed under the SUD umbrella. So those particular curriculums target SUD in general. And so part of the homework that comes along with those is for them to sort of personalize their homework and their particular substance of choice, their triggers, and personalize it from that aspect. And so our SUD services kind of covers all of the particular diagnoses. For medications in particular, what we have prescribed is the oral naltrexone and Vivitrol, which is the, I don't have it broken down by diagnosis of those who had OUD versus alcohol, but those are the primary medications that you would use for individuals who have an alcohol dependence.
And the numbers that you gave us of who was on the oral naltrexone or the Vivitrol, et cetera, those were alcohol use disorder was included in the OUD numbers you gave us?
Yeah, so those numbers on oral naltrexone and Vivitrol are not separated out by OUD and alcohol. So they could have had both diagnoses and they got that particular medication from the provider, but there are some individuals who've been treated with that medication specifically for alcohol dependence.
Thank you. And my final question, I think, is probably for Dr. Thornell, but it may be for you, Dr. Hodges. I'm sure you folks are tracking a lot of data of the success of these programs, which I, for one, and am so thankful that we're providing this service for folks. I think, just to quote my co-chair, we have sort of said those things, right? This is a prison. It's not a mental health facility. Well, actually it is, right? 51%. Unfortunately, we are dealing with that. And the same is true for folks who are dealing with substance use disorder. So I'm sure you guys want to show us and other folks the success rate of these programs. So are you collecting data both for folks who are inside and when folks transition out? And how long are you tracking the data for when folks transition out? And let me just say, Dr. Hodges, that I completely understand, and I know that people on this committee do as well, that part of recovery is stumbling. So we get that you don't, help people and then they're just fine, right? That's just, that's some fairyland world that we in this committee don't live in. So, so are you guys gathering some data, and when might there be a long enough time of these services so that we have access to that data?
Absolutely. Do you want me to take that, Dr. Thornell, or do you?
Yeah, why don't you, if you want, and I can jump in on follow-up.
Absolutely. So we are tracking quite a bit of data, as much data as we can think to track, and we throw in more things to track on a regular basis as we sort of learn and grow as a department. So we are tracking data inside as well as when they're released. The release data that we're tracking is specifically related to MAT and individuals who are maintaining their appointments and continuing with their providers. And so obviously that data is as good as the individual wants to, allow it to be. So it's dependent on them and their communication back with us, but we are tracking the post-release data for MAT. Inside, we're also tracking, obviously MAT data, but we also do tracking of information related to IMHU, mental health services in general. One of the things I didn't touch on was just sort of, we do kind of pre and post surveys for substance use treatment. And so we have them fill out surveys before they start treatment and then at the end of treatment. And so we've been doing that for a while now. We have some preliminary data that we're working on, but we are tracking because we don't want the message to be like, if it feels good, it must be working. That's not the way to do things. We want to be data driven. And so we want the information to sort of direct how we orchestrate our treatment and funnel our resources and engage in enhancements of our programs.
Yeah, and I would just add to that, if I could, Representative. First off, thanks, Dr. Hodges, for that information. And I just want to draw out one of your points, Representative. That we've made a lot of these enhancements in the last 2 years, and so not a lot of time has passed. And we are collecting a significant amount of data across the board on the behavioral health side, but elsewhere as well. And as each year, as each annual period ticks by, our reports get more comprehensive and much more significant because there's more data to be had. And we're able to compare that against release data. So people have had time out in the community for us to measure the success and effectiveness of those interventions. And so I think if you look at, we've released our MAT 1-year report. We've released our annual data reports every year, substance use treatment reports. Those become much more comprehensive every year that goes by, for exactly your point. And two other things we've recently embarked upon to support this is we now have access to the PMP data, so we can compare back against prescriptions and prescribing practices prior to incarceration and after incarceration, which gives us other measuring tools on the medical side, but also a partnership with the Health Information Network that we're finalizing that's going to provide us much more of a linkage to the medical community in Maine, and be able to share data and information back and forth in a much more fluid manner, so we're not siloed in those data points. And that will also build many more data reports and really round out what we're aiming to do.
Wonderful. All right, so this has been great. I want to see what other questions committee members have, but I also want to give you, all of the doctors in this room with us right now, anything that you want to make sure that we know before you end your time with us. You're also welcome to add that in now. And I see Representative Pluker, please.
Thank you. I wasn't sure. I was holding on a couple questions about staffing till I thought perhaps Dr. Newby was going to present. But will he not be doing a presentation?
No, I'm not going to be actually presenting, but certainly I can listen to your questions and certainly respond back to you. But or I may have a response depending on what the nature of the question is.
I just got the feeling that you were more the administrator, human resources sort.
Yeah,
so one was around hazard pay for the employees inside. I know that WellPath did that in a pretty significantly different way than DOC did it. And could you just walk me through that decision-making process about how you handled hazard pay? And not everybody in the committee might not everyone in the committee might know how you handle it. So just go ahead and give us the background and tell us about that.
Sure, I can speak to that a little. One of the things with hazard pay, you have to recognize that COVID was not something that any of us saw coming. And immediately we recognized that once this was here, there were certainly a number of hazards that staff were taking and coming and working in these environments. And then too, they were also subjected to a number of new testing protocols. And I mean, we were all concerned. I mean, masking, the whole world. So we recognized that in order to certainly retain staff and ensure that staff recognize how much we value them coming to work on a daily basis, that we felt it most appropriate that we partner with them by offering an incentive pay to come to work each day, undergoing those new risks that we were exposed to.
And then why did WellPath not decide to include it in their paychecks at the time that they were working?
Well, okay, I'm not exactly sure where you obtained all of your information from, but it was agreed upon that we would pay this out as one lump sum, and that was paid at I believe it's like 4 months in to this, but it was cumulative over the course of the pandemic onset.
Did you have like did you have a thought process behind that policy? Was that a nationwide process that you didn't have control over, or?
It was a nationwide process that we embarked upon, but again, this was something that we felt was necessary in order to retain our staff and certainly incentivize them to continue to work with us during the pandemic, as we felt this was most appropriate. And most institutions, just being mindful of this, did similar like practices.
And I think DOC continued their pay through the end of December. When did WellPath stop paying their workers hazard pay?
The WellPath incentives, I believe stopped, sometime in, I want to say like in May, and then we continued them on in any of the outbreak facilities. So once there was an outbreak that was noted and employees subjected to increased risk or hazard in working in those facilities, then we would pay them a hazard pay. Then also, just in closing out on the year, WellPath on their own, certainly we offered an additional incentive package to all those employees.
It must have been hard to know that you're working, helping residents, working side by side with folks who are getting a $5 an hour increase, for every hour they worked, and then you personally weren't getting it. That must have been tough on morale inside, I think, when those workers were facing that situation. The other question I had was, I know I think it was the medical director left this past summer. Could you talk a little bit about that change in administration?
No, I can't speak to the particulars regarding our prior medical director, but it was I'll just say it was a decision that it had come to being, and we sought out a different medical director.
Was it connected to the allegations of sexual misconduct against him?
No, this is the first time I'm ever hearing of anything of that nature.
Okay, so you have not heard any.
No.
So none of that investigation. What were you part of?
No, sir, I'm not aware of that at all, Representative. This is the first time I'm even hearing of such.
Okay, we are talking about Dr. Clinton.
I won't get into any particulars with names, but sir, if you are aware of any information, I would certainly love to be made aware of that. I'm just not. This is the very first that I'm hearing anything of that nature.
So no investigation would have occurred within WellPath without your knowledge. Is that true?
That is absolutely correct.
Okay. And do you have? Maybe you don't have this information top of your head, but do you know what day was the last day of your medical director?
That would be something that I would need to speak with representatives about in order to respond to you on that. But I mean, your inquiry or questions is quite interesting. I just don't. These are somewhat new and kind of shocking to me to hear.
Sure. Dr. Thornell, is there anything you're able to add to the conversation?
No, there's not. And, as everyone knows, I mean, we're not going to speak publicly, especially in a publicly live streamed forum regarding individual personnel decisions, whether they were DOC decisions or WellPath decisions. It's just not the forum we're even able to do so, let alone would it be what we would do in such a setting. So I don't have anything further to add.
Dr. Thornell, could you put Dr. Newby in touch with Representative Pluker so that they can talk outside of a public forum? As you know, Representative Pluker not only represents the residents inside, but he also represents many staff members of WellPath and of the Department of Corrections. So it might be helpful, Dr. Newby, for you and Representative Pluker also to be in touch. I didn't mean to interrupt you, Representative Pluker. I just thought that might be a helpful way for you to continue also.
Absolutely. I'd be happy to put them in touch and have conversations outside of this, as we have in the past with Representative Pluker.
Absolutely.
Thank you, Representative.
Thank you.
My line of questioning was more into the process of investigation. Thank you.
And Representative Pluker, I'm sorry, I didn't mean that. I wasn't saying stop your questions. You have more questions, you ask those questions. I was saying if those questions aren't able to be answered here, I'd like you to have the opportunity to communicate with Dr. Newby. I know that you have shared with me that you have communicated with Dr. Thornell about this previously, and that this is an issue you folks have talked about, a way that might, sort of help you deal with this issue with your constituents, which is also part of our job. In addition to serving on a committee, we serve our constituents. But keep going if you have other questions to ask.
Thank you. I mean, I don't have more questions. These are I'm being asked questions by my constituents about this, and so I wanted to try to. This is the first opportunity I've had to talk to representatives of WellPath, and I wanted to see if they had anything to add to the conversation. Thank you.
And it sounds like you're going to be able to have a conversation with Dr. Newby, and possibly he could help facilitate you getting information to your constituents, which I can certainly appreciate is putting a lot of pressure on you in doing your job for the folks that you represent. So thank you. Other questions from folks before we wrap up?
I just wanted to add, Representative Warren, and to all the distinguished guests on here that we're extremely appreciative of the opportunity to sit this afternoon and share comments with you on our services. We've been extremely proud of the work that we've done here in Maine and our partnership with the Department of Corrections. It's just been a phenomenal opportunity to really expand upon the services that we provide, not only as an organization, but then also to the citizens here in Maine. And we're citizens here in the state. You know, as Dr. Hodges mentioned early on, is that we weren't necessarily born here in this state, but we've all relocated here, and we certainly consider ourselves citizens of this great state and appreciate the opportunity to work here. So thank you.
Representative Warren, if I may.
Please.
Yeah, I'd just like to say that, you know, after listening to the testimony of the last couple hours, I think it's obvious to anyone listening the compassion and care of these professionals that just testified. They've dedicated their professional lives to the treatment and care of these residents here and elsewhere. And it's an honor to work with them daily. They truly care about reducing recidivism and, more importantly, care about the residents that they work with. And so I've been very pleased with the performance and the depth of professionalism, knowledge, and intellect of all the people testifying today. So I'd just like to thank that. And thank you for the forum for us to be able to indicate all the extensive programming and reduction of recidivism that we're doing. Thank you.
Thank you, Commissioner. I found today very, very helpful. I'm extremely thankful for this opportunity. So thank you for that. Any questions or comments from the committee before we close today? Thank you all. Dr. Thornell, thank you for putting this all together. We really appreciate it.
Thank you, Representative. Thank you, committee members.